reference by the Lord Advocate of legal issues under paragraph 34, Schedule 6 of the Scotland Act 1998.
Before we begin, I'm conscious that many people following this hearing may not be familiar with this court or with proceedings of this kind, so it may be helpful if I explain a few points. First, this court is the highest court in civil matters for the whole of the UK, including Scotland. It applies the law of whichever part of the UK the case comes from, including Scots law in Scottish cases. It draws its judges from all parts of the UK, including judges who have served for many years in the Scottish courts. It is based in London, but has also sat elsewhere in the UK, including Scotland. Secondly, this court has a special function under the devolution legislation. It is possible, in some circumstances, for the Lord Advocate and her opposite numbers in the other devolved governments and the UK government to refer legal questions about devolution to this court for decision. That is what the Lord Advocate has done in this case. But the UK government argues that that power cannot properly be used in the circumstances of this case, and that even if it can be used, the court in its discretion should decline to decide the question referred. So the first point the court has to decide is whether the question which the Lord Advocate has referred is one which the court can and should properly answer. If the Lord Advocate succeeds on that point, the court then needs to decide the answer to the question which she has referred, which in essence is whether the powers of the Scottish Parliament enable it to legislate for a referendum on Scottish independence. The third point that I should make clear is that despite the political context of this reference, the questions the court has to decide are limited to technical questions of law. The court will decide them by applying legal principles. Fourthly, and finally, the court will require time after the hearing to prepare its judgment. The hearing is the tip of the iceberg. We also have more than 8,000 pages of written material to consider. Therefore, as is usual, it's likely to be some months before we give our judgment. Lord Advocate.
Thank you, my Lord. Good morning, my lady. This is a reference of a devolution issue made under paragraph 34 of Schedule 6 to the Scotland Act 1998. The reference begins at EF3 and paragraph 34 of Schedule 6 is at EF 359, which is in Volume 1 of the authorities. The reference seeks the court's determination of the question: does the provision of the proposed Scottish Independence Referendum Bill that provides that the question to be asked in a referendum would be, should Scotland be an independent country, relate to reserved matters? In particular, does it relate to the union of the kingdoms of Scotland and England, paragraph 1b of Schedule 5, and or the Parliament of the United Kingdom, paragraph 1c of Schedule 5. I am going to adopt the following approach to my submission. Firstly, I propose to explain the reasons for the reference. Secondly, to draw the court's attention to materials considered to be particularly important to the court's consideration. Thirdly, to set out my position on the question of jurisdiction of this court and respond to the Advocate General's submissions on that issue. On that particular point last week, I filed a copy of my speaking notes so that the court could have the detail of that submission to avoid the need to turn up every reference. I do not understand the filing of that note to have been opposed, and the treatment of that will be a matter for the court. Next, I would propose to consider the terms of the draft bill, thereafter address the legal framework within which the question should be answered and the principles to be applied by the court, and lastly, discuss the arguments that support the question being answered in the affirmative and those that support the answer being in the negative. So might I begin by explaining the reasons for the reference to the court. The reasons why I considered it appropriate to exercise the power conferred on me by paragraph 34 are set down in the reference at paragraphs 2 to 6. That's at the electronic folder, page 5 through to 6. And also in my case at paragraphs 19 through to 24 at the electronic pages 43 and 44. This is a power that has not previously been exercised by a Lord Advocate. And I make this reference exercising my own role as Lord Advocate in line with the role that I've been given under the Scotland Act. However, I am, of course, a Minister of the Scottish Government, and it is well known that the Scottish Government's policy is that a lawful referendum should be held. In this case, I concluded that in the particular circumstances, it was necessary and in the public interest that the question should be referred. I submit that this court has jurisdiction to accept the reference, and it is in the public interest that it is answered by the court. The particular circumstances are, firstly, the Scottish Government has been elected on a manifesto commitment to hold a referendum on the question of Scottish independence in the course of the current session of the Scottish Parliament. A manifesto commitment to hold a further referendum has been approved by the Scottish electorate several times since the 2014 referendum. The history of contemporary political debate on Scottish independence and of the electoral and constitutional context in which that debate has taken is described by me in my case. At part 3 of the case, particularly paragraph D onwards at page EF 52. Importantly, as noted in the case, in the 2019 UK general election, a majority of Scottish MPs were returned on a manifesto that supported a further independence referendum being held. There's reference to that in my case at paragraph 73. And in 2021, the Scottish general election, a majority of MSPs were returned on a manifesto commitment to a referendum on independence. Again, I make reference to that in my case at paragraph 76 at EF 62. Therefore, the issue of Scottish independence is a live and significant one in Scottish electoral politics. And the Scottish Government wish to introduce a bill in the Scottish Parliament to provide for holding for a referendum. As is well understood, the question whether such a bill would be within the competence of the Scottish Parliament is contested and has been contested since the advent of devolution. The history of the debate on that question is summarised in my case. The question of the competence of an independence referendum was considered in the UK Parliament during the passage of the Scotland Bill. I make reference to that in my case at length at paragraph 48 and at electronic pages EF 53 through to 56. And there's also references made and comments made by other academic and other commentators at paragraph 24, electronic 44 of my case. Lord Mackay of Drumadoon predicted that it would become a festering issue. In my submission, he has been proved right. It is an issue that I invite this court to finally resolve. The Scotland Act contains safeguards intended to ensure that legislation introduced to and passed by the Scottish Parliament are within the Scottish Parliament's legislative competence. The Scottish Ministerial Code, which is at tab 117, electronic folder 6443, supports those safeguards. The combined effect of Section 31 of the Scotland Act 1998 and the Scottish Ministerial Code is that a minister who wishes to introduce the proposed bill cannot make the statement required under Section 31 unless the Scottish law officers have cleared the bill for introduction. I would not be able to clear a bill in the terms of that appended to the reference. That is because, as I have explained in the reference, I do not have the necessary degree of confidence that the bill would be within competence to enable me to do so. Nevertheless, I consider that the question of law raised by the proposed bill is one which is genuine and unresolved. I do not consider that it is in the public interest that on an issue of law of this exceptional public importance to the people of Scotland and the United Kingdom that I should, in effect, be the arbiter. It is not constitutionally appropriate that a law officer perform such a function. Only this court can provide an authoritative ruling and provide certainty and clarity to the Scottish Government, the Scottish Parliament and the electorate. For all these reasons, I have concluded that it is in the public interest that this court should be asked to do so. So, can I set a little bit more of a context before the court and look at some of the materials? I intend to spend some time, no more than an hour, looking at materials that are before the court that I consider are important to understanding the context for bringing this reference and for the court's determination of it. On the commitment of the Scottish Government to a referendum on Scottish independence, I would refer the court to a document, Scotland's Right to Choose, dated 2019. It's at tab 108, and the summary is included at electronic folder number 6323. The pages run from 11 through to 13, and in that document, the Scottish Government concluded that there had been a material change of circumstances since the 2014 referendum, namely the outcome of the referendum of the UK's membership of the EU in 2016 and the impact on Scotland. I also referred to the Scottish National Party election manifesto of 2021. That's at tab 112. It begins at the electronic folder number 6350, and the commitment to the referendum is at page 6360 and 6361. This is the basis on which the SNP contested the 2021 Scottish Parliament general election. Thereafter, on the existence of a genuine, unresolved issue of law, I refer the court to the debates on the Scotland Bill in 1998. Significant extracts from that are included in my case at paragraphs 49 to 51, electronic folder pages 53 through to 55, and they are reproduced in tabs 72 to 74 of the authorities, beginning at page 3728. That's at volume 6. I don't need to go through all of the detail, but the first that I would point to is an exchange between the Secretary of State for Scotland, Donald Dewar MP, and Michael Ancram MP in the Commons on the 12th of May 1998, and that is at electronic folder page 3728. Of course, all stages of this bill were taken in line with convention as to bills of constitutional importance on the floor of the House. And questions were asked whether a referendum in the Union was reserved. And Mr. Dewar responded that constitutional change was reserved. Mr. Ancram wasn't satisfied with that answer, and asked the question again, and Mr. Dure's response focused on the effect of a referendum. He said, if one assumes that this is a way of changing the Constitution, no, it is not in the power of the Scottish Parliament to change the constitutional arrangements. Scotland will, of course, have a right to enter into any debate about these matters in the United Kingdom Parliament, and there will be Scottish representatives to do so. That is as it should be. They will be expected to play a very full and proper part in debates in the United Kingdom Parliament on behalf of their constituents. The point was taken up again by Dominic Grieve MP, and Mr. Dure further responded. A referendum that purported to pave the way for something that was ultra vires is in itself ultra vires. That is a view that I take, and one to which I will hold. But as I said, the sovereignty of the Scottish people, which is often prayed in aid, and is still there in the sense that if they vote for a point of view for change and mean that they want that change by their vote, any elected politician in this country must very carefully take that into account. I do not believe that they will vote for that change, or that there is enthusiasm or a wish for that change. We shall no doubt argue about, debate and analyse that many, many times. I should also point out that there is a contribution in this debate by Mr. Salmond, Mr. Alex Salmond MP, and the answer to his question doesn't necessarily illuminate the question. However, it is relevant to note that Mr. Dure's response is that when Mr. Salmond should attempt to persuade the people to vote for candidates who support his point of view on the need for a referendum, and there is a degree of mockery that the SNP only have 5 MPs, this is of some relevance to the issue of political mandate previously discussed. It would be said by the SNP that it has done precisely what Mr. Dure suggested it should do. Then please see the House of Lords debate on the 21st of July 1998. Lord Mackay of Drumadoon was advancing amendments dealing with referendums and the competence of a referendum on independence. His contribution is at pages 3732 and 3733. He said, notwithstanding the argument explained by the Secretary of State in another place and repeated by the Lord Advocate on second reading, I believe that it would be perfectly possible to construct a respectable legal argument that it was within the legislative competence of the Scottish Parliament to pass an Act of Parliament authorising the Executive to hold a referendum on the issue of whether those who voted in Scotland wished Scotland to be separate from the UK. It would be perfectly possible to construct an argument that it would assist members of the Scottish Parliament in the discharge of their devolved legislative and executive duties to be aware of the thinking of the Scottish people on that very important issue. Lord Sewell was unequivocal in his response, and to take his response a little short, he did say that if the Parliament passed an act to hold a referendum about whether the Union should continue, it would thus clearly be legislating in relation to a reserved matter of the Union. Any such act would be about the continuation of the Union and therefore would be beyond the Parliament's competence and would not be law.
What page is that, please?
So Lord Sewell's contribution is at page EF 3737 to 3738.
Thank you.
Further, then, on the question of unresolved issue of law, it is relevant to see the views expressed by legal academics, including Cormac McCamley, yes, but is it legal, which is in tab 67 at EF 3670. This rehearses more briefly the arguments now being put before this court in this reference, without reaching a firm conclusion on what the author considers ought to be the answer the question now referred. In addition, Gavin Anderson, Christine Bell, Aileen McHarg et al., the Independence Referendum, Legality and the Contested Constitution, widening the debate, at EF 3680, tab 68, responding to the UK government consultation that said that the independence referendum was outside competence, authors consider the question less straightforward than as suggested by the UK government, and that a plausible case can be made out that such a bill would be lawful, and that is at EF 3681, tab 68. A summary of the various academic views is set in the footnote to paragraph 24 of the case at EF 44. This issue of law was not resolved by the Section 30 order made in 2013 following the Edinburgh Agreement between the Scottish and UK governments. The terms of that order are ambivalent on the question whether, absent the order, it would be within the legislative competence of the Scottish Parliament. Reference there I would make to EF 2164 and to see Article 3 of the order at EF 2168, both of which are at tab 36. This provides simply that paragraph 1 of Schedule 5 does not reserve a referendum of the kind provided for in that article. And then I'd also wish to draw the Court's attention to the materials on the history of referendums in the UK and their effect, and say something about the status of referendums in the general constitutional framework. I deal with this at Part 3, Section 1 of my case at EF 63 onwards, and at paragraphs 78 to 80 of my case, pages 63 through to 64, I set out an overview of the role and use of referendums within the United Kingdom. And I would highlight the following points which emerged from that discussion. The referendum as a constitutionally legitimate device was recognised by Dicey at the end of the 19th century, although it was not until 1973 that the modern use of the referendum began. Dicey saw the referendum as sitting above Parliament in the hierarchy of constitutional decision makers. I refer there to Dicey, the referendum, 1894, 23 National Review, page 65, which is at tab 62, page 3582 of the electronic folder. There is no consistent practice in respect of the use and legal effect of referendums. The House of Lords Constitution Committee 12th report in the session 2009 to 2010, referendums in the UK, tab 100, electronic folder, page 5100, made that statement. My case refers to the 1973 border poll in Northern Ireland, the 1975 UK referendum on continued membership of the EEC, the 1979 referendums on Scottish and Welsh devolution, the 1997 referendums on Scottish and Welsh devolution, the 2011 referendum on changes to voting system for elections to the House of Commons, the 2014 referendum on Scottish independence, and the 2016 referendum on UK's continued membership of the EU. From this we know referendums may be self-executing in that legislation authorising the referendum provides for what is to be done in response to the outcome of that referendum. See my case at paragraph 80, referring to the Parliamentary Voting Systems and Constituencies Act 2011, which required the Minister to bring into force or repeal certain provisions of the Act, depending on the outcome of the referendum on proportional representation. Section 6 of the 2011 Act is at tab 30 of the authorities at electronic folder 1236. That is tab 30 in volume 2. And referring to the devolution referendums of 1979 as being similarly self-executing, where the threshold for a yes vote was not met, the relevant Acts of Parliament were repealed. See, for example, Section 85 of the Scotland Act 1978, which I refer to at electronic folder 1051. Such self-executing referendums remain, of course, subject to the principle of parliamentary sovereignty, unlike in jurisdictions where referendums have a particular constitutionally prescribed role and function. If a UK Parliament wished to it could pass legislation to prevent the outcome of a referendum from taking effect. More commonly, however, no provision is made as to the consequence of any particular outcome from a referendum. That was the case in the Scottish Independence Referendum Act 2013, which provided for a referendum on independence. It was a position adopted by the Westminster Parliament in the European Union Referendum Act 2015, and it is the position in respect of the draft bill. A non-self-executing referendum invariably has political consequences, but in law it has no effect. They are entirely advisory. And in that respect, I refer the court to Moohan against the Lord Advocate at paragraph 47, which is at tab 8, electronic folder 6941, which is a statement, of course, of Lord Neuberger. Finally, I note that in relation to the proposals for the Scotland Bill that would establish the Scottish Parliament, and in respect of which an advisory rather than a self-executing referendum was ultimately held, Donald Dewar characterised the intended referendum as being a test of public opinion and as a matter of establishing consent. And the reference there is EF 3727, and the date that he made that statement was the 21st of May 1997. Finally, on the materials, the proposed bill is at EF 13. The bill is complete in all respects material to this reference. There are minor technical matters that would need to be dealt with before the bill could be introduced. The question referred for the answer of the court concerns only section 2, subsection 2 of the proposed bill. No more need to be said about the draft bill at this stage. It is addressed in more detail in the submissions on whether or not the bill is or is not within the Scottish Parliament's legislative competence. Moving then to jurisdiction. My position is I'm making positive submissions on the jurisdiction of this court to hear this reference, and they are set out at part 2 of my case, beginning at EF 40. The submissions in response to the Advocate General's case, so far as relating to jurisdiction of the court to hear and to determine the reference, are set out in the separate speaking note on jurisdiction. Whilst on the substance of the question referred, I seek authoritative guidance from this court and have presented both sides of the argument. I do take a positive position, though, on jurisdiction. In my submission, this court does properly have jurisdiction and should answer the question referred. So, on the positive case for jurisdiction, paragraph 34 of Schedule 6 to the Scotland Act, which is at EF 359, Volume 1, Tab 1, is straightforward in its terms. It provides that the Lord Advocate may refer to the Supreme Court any devolution issue which is not the subject of proceedings. Devolution is defined in paragraph 1 to Schedule 6, and it includes any other question arising by virtue of this Act about reserved matters. And that you can find that at EF 322, Volume 1, Tab 1. I contend that the question referred is a question arising by virtue of the Scotland Act about the reserved matters of, firstly, the Union of the Kingdoms of Scotland and England, and secondly, the Parliament of the United Kingdom. I refer to electronic folder page number 183. It is a question that arises by virtue of the Scotland Act because, firstly, it is about reserved matters, and reserved matters exist only by virtue of the Scotland Act 1998. By virtue of Section 31 of the Scotland Act 1998, electronic folder 134, it is necessary for the member introducing a bill to make a statement that the bill is within legislative competence. The member, in making such a statement, must reach a view on a question of law. In the case of a government bill, that statement cannot be made unless the bill has been cleared by the law officers. The requirements then of Section 31 and of the Ministerial Code have been acknowledged by this Court in the UNCRC reference case at paragraphs 12 and 73. That's at electronic folder 914 and 933. It's in Volume 1, Tab 15, at page 904. I say that in combination, these provisions support the principle of legality. Moreover, they support the view that the question to which the reference relates arises by virtue of the Scotland Act. Paragraph 34 of Schedule 6 allows certain law officers to obtain authoritative legal guidance from the court on the operation of the devolution scheme, where the law officer in question considers it appropriate to seek such a definitive ruling. I have explained why I consider it to be necessary and in the public interest to obtain from this court at this time an authoritative ruling on the question referred. In short, I say this: there is a genuine issue of law that is unresolved, which, if it is resolved, could permit the proposed bill to be introduced. However, absent a ruling from this court that the draft bill would be within competence, I could not clear the bill. The issue is one of exceptional public importance to the people of Scotland and the United Kingdom. The issue is directly relevant to the central manifesto pledge that has been endorsed by the Scottish electorate. I have mentioned at paragraph 24 of the case that there is academic commentary on the issue, which expresses different views, and I would add to this, there is a risk that even if I cannot clear a bill to be introduced by the Scottish Government, a bill could be introduced by an individual member of the Scottish Parliament. And that reinforces, in my respectful submission, the importance of obtaining an authoritative judicial ruling from this court at this stage. In those circumstances, I'm seeking legal certainty at this stage. It is the responsible course, and in my assessment, it is in the public interest. As I noted in my case, paragraph 25 onwards, at EF 44, I acknowledge that it is appropriate to say a word about the case Keatings against the Advocate General, which is in Volume 1, Tab 14 at page EF 880. The judgment of the Inner House in the case of Keatings does not answer the question referred to this court. I do not consider that the reasons why the court considered that the case brought by the pursuer in Keatings was academic that applies to this reference, nor do I consider that standing Keatings it's inappropriate for me to make this reference. In particular, I consider that in the current context, the reference involves a question that is now of considerable practical importance. That's reflecting the language of the Lord President when he contrasted the Keating's case with the position in Whiteman. And that's at Keating's at page EF 899 at paragraph 54. The issue doesn't arise for me in the abstract. It is a live issue. So far as paragraph 34 of Schedule 6 is concerned, I deal with that in my response to the Advocate General, but note that no detailed submissions were made to the court in Keatings in respect of paragraph 34 references. I acknowledge that the previous Lord Advocate submitted that a paragraph 34 reference could not be made during the passage of a bill, but that is not the circumstances within which this reference arises. Nothing, then, said by the Lord President in Keatings should be said to preclude a reference by the Lord Advocate in circumstances such as this. So I might then turn to the detail of my speaking note on jurisdiction and discretion, I'll take the court through this, and as I say, I hope that it assists in taking us through this lengthy and, in a sense, very technical argument, which makes significant reference to statutory and provision and case law. This responds to the Advocate General's case at electronic folder page 488, paragraph 4, and paragraph 6 through to 46, pages 89 to 103, in which the Advocate General contends that this reference is not within the court's jurisdiction under Schedule 6 of Schedule 6, paragraph 34 of the Act, and alternatively should not be entertained at the court's discretion. Schedule 6, paragraph 34, confers on the Lord Advocate, Advocate General, Attorney General, and Attorney General for Northern Ireland a power to refer directly to this court any devolution issue. That's at electronic folder page 359. The only qualification on that power is that the devolution issue is not the subject of proceedings. Schedule 6, paragraph 1, at page 322, states that for the purpose of that schedule, a devolution issue includes, at subparagraph F, any other question arising by virtue of this Act about reserved matters. Accordingly, the Lord Advocate is entitled to make a direct reference to this court pursuant to Schedule 6, paragraph 34, where paragraph 1F, where two conditions are met. Firstly, there's a question about reserved matters, and secondly, it arises by virtue of the Scotland Act. I say these conditions are satisfied. There's a question about reserved matters, namely the question identified for this court in the reference, and it arises by virtue of the Scotland Act, namely the exercise by the Lord Advocate of my function of advising the Scottish ministers for the purposes of section 31(1) of the Scotland Act. In my submission, the satisfaction of these conditions are set out clearly in my written case at paragraph 6 through to 18, at pages 40 to 43 of the electronic folder.
Could I just ask you a question about the qualification in paragraph 34 on page 359? Any devolution issue which is not the subject of proceedings.
Yes.
On my understanding, that's because elsewhere in the schedule there's a regime for the ability, if proceedings are on foot, one of the law officers to seek rulings on devolution issues. So paragraph 34 is a sweep up. It's intended to broaden it beyond that regime. Is that correct?
Yes, I agree with that, my lord, and that's how the term was described in the notes and clauses, a sweep up provision almost. Right. Yeah.
Thank you.
So the Advocate General has two distinct arguments on jurisdiction against his position. The first and principal argument is that even if the two conditions set out above are satisfied, there is an implicit exclusion in the terms of paragraph 1F, such that it does not apply to questions relating to bills or draft bills. And that's at the, I make the reference there to the Advocate General's case at that point. His second argument is that the two conditions set out in paragraph 1F are not satisfied on their own terms. And these two arguments then I address in turn. Firstly, that the conditions are not met. The Advocate General's essentially implied limitation argument. The Advocate General's first argument is premised on the assumption that the conditions of 1F are satisfied in terms, but that despite the apparently broad scope of the power to refer a question pursuant to Schedule 6, paragraph 34, read with paragraph 1F, that power cannot in fact be used where a question about a reserved matter relates to a bill or a draft bill. The reason the Advocate General gives for this implied limitation is found at paragraph 24 of his case, where it said that allowing the power to be used in circumstances such as this reference would render the provisions in section 33 for referring bills passed by the Scottish Parliament unnecessary. The nub of that reasoning is that it would be surprising if Parliament had set up such a carefully calibrated scheme in section 33 and the surrounding provisions, and yet simultaneously intended that scheme to be rendered unnecessary by the discretion afforded to the same law officers to refer a bill outside it. The short answer to the Advocate General's submission is that I am not, by this reference, seeking to refer a bill at all. Section 33 of the Scotland Act makes provision for bills passed by the Scottish Parliament to be referred to this court. But this reference concerns a question about proposed legislation that has not been introduced to the Scottish Parliament and which currently cannot be cleared by me for introduction. Leaving aside the distinct questions as to whether the reference of such a question is hypothetical or premature, that I come on to address that, there can be no objection to the reference on the grounds of inconsistency with section 33, since that section is not engaged and may never be engaged. This is a question about proposed legislation. Indeed, the Advocate General does not contend that the reference is inconsistent with the terms of section 33. I say he cannot plausibly do so. Rather, he takes the weaker position that allowing a reference in these circumstances would render the section 33 procedure to refer bills unnecessary. However, recognising the entitlement of the Lord Advocate to make references at a pre-legislative stage would not render the power of a Lord Advocate to do so under section 33 unnecessary, still less the power of the Advocate General or the Attorney General to do so pursuant to section 33. The circumstances of the present case that led to the reference being made are highly exceptional, and I set out these in my case. Absent such exceptional circumstances, concerns about whether legislation relates to reserved matters may be expected to be raised through the mechanisms provided through the Scotland Act, including section 33. I see two particular situations demonstrate the undoubted continuing importance of section 33, even as Schedule 6, paragraph 34, permits a reference to be made in the present circumstances. Firstly, where a Lord Advocate is able to clear a bill, it would not be appropriate for a reference to be made by me pursuant to paragraph 34, because no issue of law would need to be determined at that stage in order for me to discharge my function and for legislation to be introduced by the Parliament. Section 33, however, would nonetheless provide an important power for me and other law officers to refer the provisions of the bill to this court if doubts about whether they are within the legislative competence justify seeking an authoritative determination following the passage of the bill through the Parliament. Secondly, Section 33 has an obvious importance where bills are amended during their passage to include clauses that may be outside of competence, which provisions would not have been subject to Section 31. That is the provision that relates to the statement or clearance by law officers, or where the process of legislative scrutiny identifies concerns about whether particular clauses are within competence. I say that there's a further answer to the Advocate General's submission that Section 33 provides an exclusive method for raising devolution issues relating to legislation, is that it's not consistent with the express provisions of Schedule 6, paragraph 34. Schedule 6, paragraph 1A, read with 34, expressly permits the law officers to refer acts of the Scottish Parliament directly to this court. The Advocate General recognises this at paragraph 17 of his case, but doesn't confront the difficulty it poses in his argument. He states that Schedule 6, paragraph 34, allows law officers to refer acts of the Scottish Parliament to this court, which, for whatever reason, were not referred under Section 33. The Section 33 process is not an exclusive process for referring devolution issues relating to legislation to this court. That undermines the Advocate General's submission that paragraph 1A should be read as implicitly limited to questions that do not relate to bills or draft bills. In addition, the Advocate General also places reliance on the explanatory notes in the Scotland Act in his written case. However, in Imperial Tobacco, Lord Hope explained that the explanatory notes were prepared in 2004 by the Scotland Office and have no more weight than any other post-enactment commentary as to the meaning of the statute. They provide no support for the Advocate General's case. On the contrary, the explanatory note to Schedule 6, paragraph 34, emphasises this amplitude. It says this power enables the law officers to refer any various question to the Judicial Committee if it is not already the subject of judicial dispute. Likewise, the explanatory note to 1F provides examples of situations swept up by its terms, clearly identifying it as a catch-all or sweep-up provision. Contrary to the Advocate General's submission, the explanatory notes to Sections 33 and Schedule 6, paragraph 34, take the matter no further.
Do you have a page number for that explanatory note? Sorry.
So the explanatory note is at page EF 379.
379.
Yes, and I make reference to that in my speaking note, my Lord, at page 26, paragraph 34, subparagraph 2.
Thank you very much indeed.
Can I ask you, Lord Advocate, I'm wondering whether in the party's arguments the ministerial code may be given more significance than it really deserves. Under Section 31 of the Scotland Act, a person in charge of a bill shall, on or before the introduction of the bill, state that in his view the provisions of a bill would be within legislative competence. Now, the person in charge of the bill may very well not be the Lord Advocate. But in the case of a bill of this nature, it would be some minister in the Scottish Government, I presume.
Yes.
And that person, in order to make the requisite statement, would require legal advice from somebody. And obviously the law officers are the authoritative source of legal advice as far as the Scottish Government is concerned. Am I right so far?
Yes, that is exactly right, my lord.
Now, it so happens the Ministerial Code formalises that in a document that's of an administrative character. It's not a piece of legislation, the Ministerial Code. But leaving aside the argument about Section 33, references of bills for the moment, if one leaves that out of the picture, if the person in charge of the bill is not clear as to whether its provisions would be within legislative competence, or if the person from whom he would receive advice about its legislative competence isn't clear, I wonder whether there's any problem about saying that would be a question arising, that the competence of the bill would be a question arising by virtue of this Act.
Yes, I agree with that, my lord. The requirement for the certificate rests with the minister introducing the bill.
Yes.
And so the whole issue about legislative competence arises by virtue of the Act.
Yes.
So the minister who's proposing the bill has to consciously and responsibly apply their mind to the Section 31 test.
Mm.
As a matter of law, the minister is not bound by the Lord Advocate's advice, and there may be circumstances in which the minister could probably take a different view.
Mm.
However, that view would really require to be underpinned by rationale, on a rational basis, and a view reached in good faith. And even though the ministerial code is there, and it requires the bill to be cleared by the Lord Advocate before the statement's made, there's no doubt that the whole issue of this, where this issue arises by virtue of Section 31.
Yes, and we have to remember that by virtue of is a phrase of a statutory definition.
That's right.
Which includes under.
Yes. So I think the Advocate General makes a point that I'm introducing a self-imposed barrier by virtue of the way in which I've looked at matters and applied the ministerial code.
Yes.
And for that reason, this issue doesn't arise by virtue of the Act. But it plainly does, because the whole question of legislative competence has to be addressed by the minister presenting the bill to Parliament, and he or she could not do so if he didn't consider it was within competence.
Thank you.
But just to follow on that, you just said they couldn't do that unless they considered it to be within competence. But what is it that prevents them from taking a different view from the law officers if the law officers say, I don't believe this is in legislative competence, but the person in charge has the view that it is? What is it that stops them from saying, thank you for your advice, but I am prepared to make that statement?
Well, that would be a significant departure from the way in which government operates currently. But there is nothing, as I've said, as a matter of law, the minister is not bound by the Lord Advocate's advice, and there may be circumstances where they could properly take a different view. But that different view has to be based on a sound rationale and reached in good faith. And the norm is that ministers of the Scottish Government take advice from the law officers who are Scottish ministers. And it would be an unusual circumstance for it to be reached that the minister didn't accept or agree with the law officer's advice. But in principle, my lady makes a reasonable point.
And could I just check if I've understood one implication of the point that you've just been making in answer to my Lord Reid? As I understand the position that you're adopting, the devolution issue that arises in a case such as this, you say, goes to whether a bill is within the legislative competence of the Parliament and that's legislative, or potentially legislative competence under any of the heads in section 29(2). It's page 129. So it's not just confined to reserved matters. It would could be in relation to breach of restrictions in Schedule 4 and so on.
Yes, but the issues here are particularly, the issue in this case is the question of a reserved matter, of course.
Yes,
Yeah.
no, the reason that I just wanted to check that that is the way that you're putting it, because we're going to come on to an argument, as I think, from Sir James about bifurcation of issues, that you can get a reference which wouldn't resolve all matters because you're concerned with reserved matters.
Yes,
but in fact, as I understand your argument, a reference under paragraph 34, because it's about a devolution issue, if it's framed, if the devolution issue is specifically about the legislative competence of the Parliament, is capable of encompassing any or all of the matters in section 29(2). In other words,
I think that
the bifurcation problem may not be such a problem as was suggested in the written argument.
Well, I think I come on to deal with bifurcation, and I could possibly come back to that.
Yes, certainly. I just wanted to check that I was understanding your argument
come back
correctly.
To that point. Yes.
All right.
Well, yes.
So I think the question that Lord Reid was asking was about section 31. I'll come back on paragraph 34. I think it does relate solely to reserved matters. I'll come back on the point that my Lord Sales has made in answer.
Yes, I mean, you can only the point I was wanting to explore really was in relation to the argument which Sir James makes in his written case, that really the connection with the Scotland Act is not sufficiently direct because it's mediated through internal practices of the Scottish Government reflected in the ministerial code. So the point I was wanting to explore with you was whether really the nub of the matter is that where there is uncertainty on the part of the Scottish Government, of a responsible minister in it, as to whether a bill would be within legislative competence, then that issue of competence would be an issue arising under the Act, which you might want to refer so far as you competently can, but are you not limited by the fact that references under paragraph 34 can only be of devolution issues?
Yes, that's right.
And your whether or not the matter could go any wider in terms of the definition of devolution issues in paragraph 1 of Schedule 6, you're confining yourself to the issue of reserved matters.
That's right.
Yeah.
Yes.
So I think you have to accept that that if there were room for a question about competence on another basis, such as impinging on legislation which was protected against modification,
yes,
you wouldn't be able to refer that issue.
No, that's exactly right. Yes.
You said a little while ago, you referred to the possibility of an individual member, not a minister, introducing a bill along similar lines as the bill you're referring. Could you just clarify whether you say that that would be then the person in charge of the bill who would have to make that statement?
Yes.
But I think you were saying they would not need to seek the advice of the law officers because the ministerial code does not apply to them. They could just state their view.
Yes.
Could you just clarify whether, if that were what were about to happen, do you say that you would have a power to refer the question under paragraph 34 in that situation?
I'll come back. I'm not sure about, I need to think about that point, and I'll come back with a particular answer on it. But I think what would be helpful to know is that a member's bill is a public bill introduced by an individual MSP, and the MSP in charge of the bill has to make the statement that the bill would be within competence in their view, and that wouldn't require taking advice from the Lord Advocate, government legal advice. The bill also can be introduced with a positive or negative statement on competence by the presiding officer, and the Lord Advocate, Advocate General for Scotland and the Attorney General can refer a bill which is considered to be outside competence to the Supreme Court, as with any bill after the bill is passed. So there is a mechanism within the Scotland Act to allow for a private member's bill at a later stage after introduction to be referred in accordance with the statutory scheme. So it's just a different procedure, but there is mechanism under the Act for a reference after the bill has been presented and has passed through parliamentary procedure.
I would be interested to your answer, if someone who is not a minister was proposing to introduce a bill, had stated that in their view it would be within legislative competence, you or another law officer disagreed with that, do you say that you would have power to refer the bill before it was introduced?
Mm-hmm. Yes, I'll consider that point against the fact that there is procedure within the Act for the appropriate reference to be made in accordance with the legislative provisions of the Act. And it might be that in that situation that should be the course that's followed, but I'll take that point and come back on it. I think I was dealing with the explanatory notes and notes on clauses, and I'd got to, I think, paragraph 35 of my speaking notes. It's 16, let's say 16, okay, paragraph 16 of my speaking notes. The Advocate General also refers to the Notes and Clauses document produced during the passage of the Scotland Act, which are said to clearly indicate a lack of intention on the part of Parliament to include questions about bills outside of the Section 33 process. The Lord Advocate accepts that the Notes and Clauses are an admissible aid to the construction of the Scotland Act. On the basis, however, of the Advocate General submissions, is that, like the explanatory note, the Notes and Clauses document emphasises that Schedule 6, paragraph 34, is intended to allow any various question to refer to the court. But unlike the explanatory note, the Notes and Clauses refers to an exception, a various question that has arisen in proceedings on a bill before the Scottish Parliament. And the Advocate General relies on this reference to this exception. In relation to Notes and Clauses, I say that the document does not, however, assist the Advocate General's argument. If it does anything, it provides assistance and supports the Lord Advocate's position. The present reference has not arisen in proceedings on a bill and doesn't relate to a bill currently before the Scottish Parliament. Thus, the single exception identified in the Notes and Clauses to the power to refer to this court pursuant to paragraph 34 doesn't apply to this reference. Moreover, the material part of paragraph 1F was not included in that subparagraph at the time of the Scotland's Bill introduction or when the Notes and Clauses document was produced. That was produced in January 1998. And the relevant wording of 1F was introduced by amendment later in October of 1998. The Advocate General also makes a series of submissions of his written case at pages 94 through to 96, to which I would make specific response. At paragraph 25, he relies on the fact that Schedule 6, paragraph 1 does not refer to a bill in any form or at any stage. This is correct, but it is irrelevant given the broad amplitude of 1F. As I say, its nature is as a sweep-up clause, and the fact that the Lord Advocate has not referred a bill. At 25.2, he also relies on an observation in Keating's, page EF 901, that only a provision of an Act of the Scottish Parliament can be outside competence. This is a variation on the Advocate General's contention that the reference relates to a hypothetical question and that it's premature. I'll respond to that in Part B later, but in short, my answer is that a question relating to a reserved matter has arisen under the Scotland Act, and given my responsibility to advise the Scottish ministers on draft legislation prior to its introduction, the issue is not hypothetical, it's not premature for it to be resolved. The Advocate General relies on explanatory notes and clauses documents, and I've referred to these. And thereafter he goes on to state that I have not provided an explanation as to why section 33.4 mandates that any reference pursuant to section 33.1 relating to a bill shall be made within 4 weeks of passing a bill or 4 weeks after post-reference approval, pursuant to standing orders made pursuant to section 36.5. And I say one obvious explanation is that this is intended to minimise disruption to parliamentary proceedings by stipulating that references under section 33 relating to bills or provisions in bills should be made post-passage in the prescribed period. The present reference, since it relates to an issue that has arisen before legislation has been introduced, doesn't frustrate or affect such a rationale. Thereafter, the Advocate General contends, by reference to comments of the Lord President in Keating's, that the Section 33 reference procedure would be rendered redundant, or it would be a recipe for chaos if a reference could be made in the present circumstances. However, at paragraph 61 of Keating's, the Lord President was referring to a quite different situation, namely the Court of Session, or in principle the Sheriff Court, having jurisdiction to entertain applications about the varies of bills during their passage prior to royal assent. Thus, the Lord President stated that it would be a recipe for chaos if third parties could bring challenges to the varies of provisions in bills in the Court of Session or the Sheriff Court during the passage of the legislation. It was, moreover, expressly by reference to the possibility of law officers being able to make such applications to the Court of Session or the Sheriff Court during the passage of legislation that His Lordship stated that the reference procedure under Section 33 would be rendered somewhat redundant. I say that these remarks are simply not in point in the present reference. Firstly, it doesn't engage the jurisdiction of the Court of Session or Sheriff Court. And secondly, it's not concerned with provisions of a bill during its passage through the Scottish Parliament.
So do you accept then that once a bill has been introduced into Parliament, the Section 33 mechanism supersedes the 1F power?
But there are certain circumstances that I could foresee that 1F would come into play. I had particularly thought about that, where a bill had been presented. Just get my thinking on that. Yes, so having thought about that matter in particular, my lady, what I'd say is I wouldn't wish to rule out the possibility of that happening, although I would accept that generally it wouldn't be appropriate. And I've thought of examples in that respect. It might be, for example, there's an issue of urgency on which there is political stalemate in the Parliament because For example, parliamentarians are divided on the issue of whether the bill is within competence. Another example might be where urgent legislation is important for national security, and it would be contrary to the public interest for there to be a delay in the determination of an issue of competence before the legislation came into effect. So fundamentally and ultimately, it is a question of the rule of law. The boundary of reserved matters is a question of law and is a question ultimately for this court. And if the rule of law and the proper functioning of the Parliament required an issue to be resolved, then I cannot say that the Lord Advocate of the day would not consider a reference. But we are, I think, in this circumstance, my lady, talking about hard to conceive and inherently exceptional circumstances.
Well, just thinking in terms of the question posed at page 9, and following on from Lord Reid's observations, the essence of the case, as far as I understand it, is that it's impossible for you to advise in the present state of the law as to whether it is or within or without competence. And I was wondering whether the question should be slightly rephrased, namely, is it possible for the Lord Advocate to advise that, or is it possible for the Minister to make a Section 31 statement that, if that is the real issue?
I think we have to go back to the terms of Section 31.
Yes.
And just reminding myself of precise terminology in Section 31. It's at page 134 of the electronic bundle, and says that in terms of Section 31, which is pre-enactment safeguards that were so...
So what page number is it again, sorry?
EF page 134, my lord.
134, thank you.
Section 31 is one of the pre-legislative safeguards and requires for scrutiny of the bills for legislative competence and protected subject matter. And it provides this: a person in charge of the bill shall, on or before the introduction of the bill to the Parliament, state that in his view the provisions of the bill would be within legislative competence of the Parliament. So they have to actually, that is what is required in terms of the statutory certificate before the introduction of the bill. So they have to be able to say that it would be within competence. And I think that's the point that my Lord Reid was making about the fact that this issue does arise by virtue of the terms of the Act. The Minister making the statement has a public law duty to make the statement on a rational and lawful basis. And as I say, that is informed by the advice of the law officers of the day. So in this case, I couldn't clear a certificate in terms of ministerial code, and in addition, because of the state of the law, the person in charge of the bill couldn't make good his obligations or her obligations in terms of Section 31 of the Act.
And I suppose you can contrast that with subsection 2, where the presiding officer can say
Yes.
their view, whether it does or it doesn't.
It can still be
It's not
introduced.
determinative about the process, it's just a view. But
That's right.
you're emphasising that in subsection 1 it is determinative
Yes.
of whether the process can continue.
Yes. And it is an important pre-enactment safeguard, and one that's required to be taken extremely seriously for all of the reasons rehearsed in the UNCRC bill case and others. So I was then going to move on to yes, so I'm making reference to the Advocate General's submissions at in his case at paragraph 25.6, that the Lord Advocate's power to refer a matter to this court pursuant to Schedule 6, paragraph 34, is limited to reserved matters and doesn't embrace all possible issues of legislative competence. I say that's correct but irrelevant, and I point again to the sweep-up provision in Schedule 6, 1F, which relates only to questions about reserved matters and doesn't extend to a number of other issues that could arise under the Scotland Act. Not only Schedule 4 issues, I think what we've been touching on, but also, for example, compatibility with the European Convention on Human Rights. But that's no indication that there should be a restriction on the circumstances in which a reference can be made where a reserved matter does arise, as in this case.
So if there were questions in relation to a draft bill on other grounds than reserved matters, it couldn't be referred under this procedure.
That's correct.
But if it were then introduced,
Yes.
there would ultimately have to be a use of the Section 33 procedure.
That's exactly right. So they would have to be considered pre-introduction by the law officers of the day and by the minister presenting the bill, and thereafter, during the parliamentary process, these issues would be open for scrutiny under the pre-enactment provisions that we've touched on.
Thank you.
So in relation to the...
Can I just ask
Yes.
on that, do you offer any sort of explanation why reserved matters should have been singled out in that way?
Why there was a difference made between reserved matters as opposed to others
Yes.
in the process. I could think about that and theorise on that at a later stage. I think the point is for an opportunity under the Scotland Act to bring forward in as quickly a good and quickly way as possible these issues for the determination by the Supreme Court to enable the smooth running of the Scotland Act. So there's a whole series of stages at which legislation can be considered and referred to the Supreme Court under the Scotland Act, but there must have thought to have been a necessary opportunity for an issue like this to arise and for authority to be granted, or rather an authoritative ruling from the court to be given over an issue that's concerning law officers of the day. So it's just another process, another way in which the law officers of the day and the Scottish ministers who seek to govern in accordance with the rule of law can seek an authoritative ruling from the court. And another way in which we can make sure that pre-enactment safeguards are properly made good use of.
I mean, I was wondering whether there's any basis, and maybe there isn't, for saying that reserved matters are, if you like, particularly fundamental to the constitutional arrangement created by the Scotland Act, because they go to the reservation of matters to the United Kingdom Parliament as opposed to the Scotland Act.
Mm-hmm. Well, I could see that would be a good reason to single them out for different treatment, but I hope to come back on that particular
All right,
point.
thank you.
Before we leave it, it might be thought odd, perhaps, that there's an additional procedure available in respect of reserved matters when there is none in respect of other matters which might be equally fundamental, such as other restrictions or incompatibility with convention right.
Mm-hmm. Well, I think that this is an issue of bifurcation, obviously, that the Advocate General is pointing to. But because some and not all of the issues concerning legislative competence could be referred by me at this stage, and some can be referred only to enactment. This possibility arises because 1F is not directed specifically at the present situation, but is intended as a sweep-up provision, allowing me to refer questions relating to reserved matters whenever they arise. And the fact that 1F only provides a sweep-up in respect of questions of reserved matters is, in a sense, no reason to cut down the extent, the amplitude of the power it confers. And that would be effectively to read down or rewrite the scheme. But the fact is that the opportunity is there for this issue to be raised under the Scotland Act.
Yes, thank you.
Yeah.
gain any assistance in either direction from the fact that those words on which you rely are included in 1F, which deals first, at least, with devolved competence, which is a separate concept defined elsewhere in the Act, rather than being 1G. Any other question? Would there be an argument that one reads it as part of a provision dealing with functions rather than legislative activity?
So, I'm not quite sure the answer to that question. I think the explanatory notes, the notes on clauses, are quite helpful in that regard, and perhaps it would just be helpful to go there. But I think the point is that it was the legislation under the Scotland Act was a fundamental change to the constitutional arrangement of this country, and it produced, in a sense, innovative procedures in order to ensure that the Parliament acted within the confines of the powers given to it. And the process available under F is one that allows the legislature, the ministers, to be able to access the courts for an authoritative ruling on a devolved competence issue where it relates to a reserved matter. And I think it was just to ensure that any matter that related to an issue of reservation could be dealt with by this court, that there should be no restriction on that. So the paragraph 1 enumerates A through to E a whole series of questions about acts of the Scottish Parliament and functions of the Scottish ministers, and whether or not they breach they're within devolved competence or incompatible with convention rights. But F specifically is the sweep-up provision giving the opportunity to raise any other question arising under the Act to this court. I think that's...
But I mean, the point's been made that it doesn't sweep up everything.
No, that's right.
I think we're looking just for some assistance as to whether there's any underlying theory why it sweeps up reserved matters, but not other matters. For instance, the convention right points that my Lord Lloyd Jones referred to.
Well, I'll come back, as I say, I'll come back on that particular point. It might be that we can find in some background material a complete answer to that question.
Just before you move on, I think you said that paragraph 1F was introduced at a later stage in the bill progress.
Yes.
After initial introduction. And can I ask, were there any explanatory notes specifically in relation to paragraph 1F? Or was it just done in the ordinary course of parliamentary procedure without explanatory notes being introduced alongside the amendment?
Yeah. Yes. There's no explanatory note, only an internal government instruction that we can supply a copy of that.
Yes, I think the only thing we're puzzled about at the moment, and is simply why Parliament focused in 1F on one particular aspect of competence, namely reserved matters, rather than other aspects of competence, all aspects of competence.
Yes. And as I say, I'll try and find it.
Yes, I mean, we do have to be a little bit careful if it's an internal government note, because that's not a permissible way to help us interpret the Act.
So I'd offer to supply it, but perhaps not then.
Well, if I could suggest this, perhaps you could have a look at to see whether it helps you make a submission to us about what the underlying reason might have been, rather than introducing it as something that we can
I'll do that.
refer to.
Thank you, Lord. I was coming on to deal with the I was dealing there with the bifurcation point, and the next point in the Advocate General's case at paragraph 25(7, he has also submitted that I haven't addressed why Parliament would have intended that legislation could be subject to a reference prior to introduction and potentially again following enactment if its terms are altered by Parliament. And he said, it said that there needs to be an explanation for the potential burden it would impose, he says, on the finite resources of this court. And my position is the answer to this is simple. As the present case demonstrates, circumstances can arise where if a reference to this court cannot be made, a bill cannot be introduced, and no determination of its legality can be obtained from the court. So the existence of the catch-all provision itself indicates that Parliament recognised that not all situations in which a reference to this court would be appropriate could be foreseen. And given the rule of law requires the proper interpretation of legislation to be a matter for the courts, my point that I made before, the catch-all provision simply facilitates the operation of the rule of law.
I mean, it's to come back to the same point, that the same difficulty arises because it's basically because of the mismatch between section 31(1), which says a statement's got to be given about legislative competence, and legislative competence covers all matters within, 29 subsection 2, which isn't just reserved matters. So mismatch between section 31 subsection 1 and paragraph 1F in Schedule 6, which just focuses on reserved matters. So, I mean, the point you make in paragraph 26 of your speaking note could have been made more generally. But again, speaking for myself, it's a bit of a puzzle why it's a point that can be made about reserved matters, but not could have been made, but doesn't arise in relation to the other matters going to legislative competence.
Yes, I understand the point.
All right, thank you.
So, what my point is...
Sorry, you said earlier also that you accepted that if something has been, if a bill has been referred at this stage, pre-introduction, then one couldn't refer, or a different law officer couldn't refer effectively the same question to the court using section 33. Is that something that's prevented by the Act, or is that just that it would already have been decided and it would be raised judicata?
There would be no sense in doing so. It had been decided. I mean, if I've come here for a ruling on the competency of the bill under the procedure I'm seeking at the moment, it would make no sense to come back again under section 33.
Yes, I understand that as a practical answer, but is there a legal... is there something as a matter of law that rules that out?
I don't think there is a matter of law, and I think I've sought to explain that there might be exceptional circumstances that would arise under. I think I hoped I'd answered that previously in the question that was asked by my lady. But what I see is that there's actually no prospect of a provision in legislation that's been introduced being referred by any of the officers to or entertained by this court again, unless it's undergone a material amendment during its passage through the Scottish Parliament. And I say that the concerns that are raised by the Advocate General about the burden on the finite resources of this court are simply not realistic.
I know you're going to come on to deal with discretion, but presumably, in the circumstances postulated by my lady, Lady Rose, in the absence of any exceptional circumstances to justify it, this court would say that there was a discretion not to address the same question again.
Yes.
And the reference would be considered pointless.
Yes, of course. So, finally, at paragraph 25(8), the Advocate General submitted that if I can make the reference in these circumstances, so could he. But I think that that doesn't follow. I say in the present case, as I've explained in my written case, a question about reserved matters arises for me by virtue of the Scotland Act. Because of my functions in advising the Scottish ministers, I'm required to form an opinion on whether or not the draft bill relates to a reserved matter. The Advocate General is simply not in a comparable situation. However, one might postulate this: if, for example, the Prime Minister of the UK was considering whether to make an order under Section 30 in respect of an independence referendum or another matter, and wished to have an authoritative ruling on whether or not such an order was necessary, or whether the Scottish Parliament already had legislative competence in respect of the matter, such a situation might be one which the Advocate General or indeed the Attorney General might have jurisdiction and consider it appropriate to make reference to this court. But he is in a very different position from me because of the particular responsibilities that I have in law by virtue of the Scotland Act. And in relation to the second issue posed, which is whether or not the question arises by virtue of the Act, at paragraph 26 of the Advocate General's case, he submits that there's no reserved matter arising by virtue of the Act, and therefore paragraph 1F is not satisfied on its own terms. The Advocate General's argument is that the statement required by section 31(1) is to be made by a minister, and no part of the Lord Advocate's role is prescribed under the Act. We've touched on this in discussion, but I say he's wrong for the following reasons. Firstly, the words arising by virtue of this Act, used in Schedule 6 1F, on their natural and ordinary meaning, require only that the Scotland Act causes an issue about reserved matters to arise. Furthermore, the first part of Schedule 6 1F refers to whether a function is exercisable. The wording, as well as similar wording in 1B to D, makes plain that the subsequent general sweep-up words that refer to any other question arising by virtue of the Act are not limited to the exercise of functions conferred by the Act. If, as the Advocate General contended, 1F was restricted to questions that arise in the course of decisions and are expressly prescribed by the Scotland Act, then the scope of 1F would be very narrow and potentially non-existent. And the Advocate General does not provide any examples of decisions that would be prescribed by the Scotland Act that could give rise to questions about reserved matters to which he contends Schedule 6 1F and 34 could apply. I say that such a narrow construction would have significant implications for Schedule 6 in general. Schedule 6 is not principally concerned with references to this court. It's principally concerned with devolution issues that arise in legal proceedings in the United Kingdom's courts. And the broad amplitude of 1F is apt to sweep up all issues about reserved matters that could arise in legal proceedings and then bring them within the scope of Schedule 6. However, if 1F was read very narrowly in the manner contended for by the Advocate General, driven by a perceived need to limit the circumstances in which references to this court could be made, pursuant to paragraph 34, so that it's understood as referring only to decisions prescribed by the Act, the effect would be that the legitimate questions about reserved matters could arise in legal proceedings, but the provisions of Schedule 6, Parts 2, 3 or 4 would not be engaged because it could not be shown that the issue arose pursuant to a decision prescribed by the Act. And I say that simply wasn't Parliament's intention to have such a narrow construction.
I see just as a matter of interest that the Northern Ireland Act adopts the same approach to devolution issues.
Yes.
paragraph 1 of Schedule 10 has a number of sub-paragraphs dealing with competence, issues of competence, and then the sweep up at the end is any question arising under this Act about accepted or reserved matters.
Yes.
So whatever the explanation is, there's a family likeness.
Yes, yes. Well, I'll certainly try and resolve the question over lunch. Or
just on that, can I ask which came first, the Northern Ireland Act or the Scotland Act?
I think it was the Scotland Act, but I'll
Right.
double check.
Beside each other in the statute book.
Yes, the Northern Ireland Act is Chapter 47, and the Scotland Act is Chapter 46.
Yeah.
There we go.
So,
And I'm so sorry to press on this, but it might be worth checking in relation to the Northern Ireland Act, since I assume that they were more or less progressing through Parliament at about the same time, whether there are any public explanatory notes in
Yes.
relation to the
distinction.
format that
Yes.
was used in that Act.
I'll do that, my lord.
All right, thank you.
So just to be clear then, in the circumstances of this reference, a question relating to a reserved matter arises by virtue of the Act because it's about reserved matters, and reserved matters exist only by virtue of the Scotland Act. In relation to Section 31, it is necessary for a member of the Scottish Government introducing a bill to make a statement that the bill is within competence, and that's extended to any member introducing a bill by Section 6 of the Scotland Act 2012. It is natural and obvious that law officers will advise on that question. The requirement for law officers' advice is now embodied in the Scottish Ministerial Code, which has been recognised by this court in the UNCRC case, and there's reference there in my speaking note to that particular case, and the fact that it's part of the safeguards arising from the Scotland Act. The Advocate General submits that contrary to the true basis for the reference is the creation of a self-imposed hurdle to Section 31(1) derived from the Scottish Ministerial Code. However, the Code reflects the safeguards built into the Scotland Act, and even if the Code didn't require me as Lord Advocate to clear draft bills prior to introduction, I would need to advise on whether the bills would be within legislative competence. Finally, the Advocate General's reliance on the reference by the Attorney General for Northern Ireland of devolution issues to the Supreme Court case in 2020, I say that his reliance there is also misplaced. That case is not analogous to the present situation. In that case, it was held that the preparation of lists of postcodes for commencing welfare provisions was too remote from the question of whether the provisions themselves were compatible with the European Convention on Human Rights to give rise to a devolution issue. In the present case, the question whether the draft bill relates to a reserved matter arises directly and squarely for determination by the law officer, the Lord Advocate. There is a separate issue raised by the Advocate General as to whether or not there is a lacuna if no reference can be made. And he says that there's no lacuna or imperfection in the statutory scheme if legislation cannot be introduced by the Parliament, because the Lord Advocate doesn't have the requisite degree of confidence that would be within competence, and the issue cannot be referred to this court for an authoritative ruling. The Advocate General submits that if the Scottish law officers consider the provision to be outside competence, the UK Parliament would not have intended the time of this court to be taken up resolving it. My position is there's no basis for this assertion as to Parliament's intention. It's far more likely, and in accordance with the rule of law, that Parliament intended that this court would have jurisdiction to provide an authoritative determination of issues of law that arise under the Scotland Act in circumstances where I consider that a reference to this court is appropriate and in the public interest. The fact that Parliament intended this court to be capable of resolving issues of law properly arise, and the Lord Advocate should, I say, not be put in the position of the ultimate arbiter with no ability to seek a ruling of this court where appropriate, is reflected in the scheme of the Scotland Act in the very broad and legally innovative provisions for the Lord Advocate and other law officers to refer questions directly to this court. And I say there's no reason to think that this will overburden this court. The fact that the ability to make references directly to this court is limited to specified law officers and in the present context to the Lord Advocate pursuant to the retained function that I have under the Scotland Act. This provides assurance that the references will be made sparingly and properly, and this is the first reference by a Lord Advocate in 23 years. This court also retains the power to ensure that references are appropriate. So coming on then to deal with the question of the court's discretion about allowing this matter, this reference, to be heard, the Advocate General submits that even if this court has jurisdiction, it should refuse to determine the reference in its discretion on the basis that it's advisory, abstract, hypothetical and premature. I say that it's simply not the correct characterisation of the reference. It is of course correct that the reference is advisory, but that is the nature of the reference procedure. In the Supreme Court of Canada, in the case of reference re-secession of Quebec, which I quote in my speaking note, the court said on a direct reference it's not acting in its traditional adjudicative capacity and it's not engaged in the disposition of rights. For the same reason, the Supreme Court explained that a reference process inherently involves the determination of issues that otherwise may not be ripe for decision because they've not arisen in the context of a legal dispute. That is the case in this context, since a reference pursuant to paragraph 34 of Schedule 6 can only be made in relation to issues that are not the subject of legal proceedings. So despite such inherent features of a reference procedure, this reference is made to obtain an authoritative ruling on a concrete legal issue that I say has crystallised. That question is not premature. It is a question that Section 31 of the Scotland Act requires the Minister in charge of a bill to ask and answer, and on which the Lord Advocate must advise. The answer to the question will have concrete effects. It will determine whether the draft bill is introduced to the Scottish Parliament or not, and trigger the statutory provisions applicable to the enactment of primary legislation under the Scotland Act. I don't shy away from the fact that it's less than ideal that this court should be asked to examine a question relating to a provision to be included in a bill that has not yet been passed by the Scottish Parliament and not accompanied by some of the associated materials that often accompany modern legislation. But the reference relates to a legal question that the Scotland Act requires persons in charge of the bill to pose themselves, and respect of which it's the responsibility of the Lord Advocate to advise ministers upon. If ministers and the Lord Advocate must consider and reach a view on whether a provision would be within legislative competence without those materials, there is no reason in logic or in principle why this court should not be able to do so in a proper case. So in his arguments on discretion, the Advocate General relies on the case of Yalland against the Secretary of State for exiting the European Union. But I say that case provides no support for his position. I make a number of points in my speaking notes. The court in Yalland emphasised that as a general rule, the courts are concerned with adjudicating on issues of law that have already arisen. That general rule is observed in this case, as the issue of law has already arisen for determination. the Lord Advocate must determine it in order to advise ministers for the purposes of Section 31 of the Scotland Act. The court in Yalland went on to state, in a passage in which the Advocate General places particular reliance, that when issues of law depend on future legislation, it will generally not be appropriate to make rulings on questions of law until the precise terms of the legislation are known. However, in this case, the legal issues that fall to be determined does not depend upon the terms of future legislation. It depends entirely on the terms of the draft bill. The legal issue posed for ministers by Section 31 relates to a draft bill, which they intend to introduce, not to enacted legislation. Similarly, in relation to the comments made by the Advocate General in relation to the Counsel General for Wales against Secretary of State for Business and Energy case, referred to in my speaking note, I say his case doesn't support his submission that the legal issue is abstract, premature or hypothetical. In that case, the Counsel General for Wales sought a declaration as to the powers of the Senate in the absence of even legislative proposals. The court held until legislation is proposed, it would not be clear whether such legislation would fall within a reserved matter. It was better, the court held, that the issue be tested by reference to proposed Senate legislation rather than in the abstract. That, as I say, is unexceptional, but has no relevance to the present case, where the legislation proposed is proposed and a concrete decision under the Scotland Act falls to be made in respect of it. And thereafter, the Advocate General relies on the case of Keatings in his recent case, in which the Lord President identified a number of circumstances as justifying not entertaining the challenge in that case. It is said that most of these apply with the same force to this present reference. There were 5 reasons given by the Lord President in Keatings. They were: there was a draft bill that may or may not be introduced, depending upon the government formed as a consequence of the election. If the introduced draft bill may or may not be in the form that it was before the court, the bill may or may not be passed at all or in the same form, and the UK government may or may not be prepared to make an order permitting a referendum pursuant to Section 30 of the Scotland Act. And if passed without such an order having been made, the bill would likely to be referred to the Supreme Court pursuant to Section 33. So, contrary to the Advocate General's case, none of these reasons apply to this reference. Indeed, rather than providing a basis for refusing to entertain the reference, they demonstrate why it's not hypothetical or premature. So, by reference to each of the reasons set out in 1 to 5 by the Lord President, as I've listed in my note, firstly, the election has concluded that the Scottish Government will introduce the draft bill that is before this court, if cleared by me. All relevant provisions of the bill, material to the devolution issue referred, will be introduced in the form that they are in before this court. Whilst the bill may or may not be passed, a prior issue arises, which is the need for the statement pursuant to Section 31 of the Scotland Act, which depends upon the draft bill in its current form, not its enacted form. Fourthly, the UK government has made it clear that it is opposed to the referendum, and the legal issue will not be referred to this court post-enactment because the bill cannot presently be introduced, so that stage will just not be reached. Therefore, I say, tested against the reasons given by the Lord President in Keatings, the present reference is not academic or premature. And I say the Advocate General's submissions to the effect that this court should refuse to entertain the reference should therefore be rejected. So I move on then to deal with my submissions on legislative competence. And I propose to take these submissions under 5 broad headings. Firstly, I will address the draft bill. Secondly, I'll address the relevant case law on the test to be applied under section 29(2) and 3 on the issue relates to in terms of the Scotland Act. Thirdly, I will address the argument to the effect that the draft bill does not relate to the Union and is therefore not within, it does relate to the Union, does relate to the Union and is therefore not within the competence of the Scottish Parliament. Fourthly, I'll address the opposing case to the effect that the draft bill does not relate to the Union and is therefore within the competence of the Scottish Parliament, as I've done in our written case, and recognising the thrust of the Advocate General's submissions, I propose to spend more time on this argument, that the bill is within competence. Fifthly, I will much more briefly address the competing arguments on whether the bill relates to the United Kingdom Parliament. And so I now propose to turn to the draft bill. So, holding a referendum is not a reserved matter. Paragraph B3 of Schedule 5 that deals with elections doesn't reserve the holding of referendums. So in that respect, I refer to the authority at tab 1, electronic folder page 206 to 208. And of course, the basic structure of the Scotland Act is that the Scottish Parliament has plenary powers to legislate on all matters other than those which are specifically reserved. It is a reserved power model. Detailed general provision for the conduct and regulation of referendums has been made by the Scottish Parliament in the Referendums Scotland Act 2020. And that is produced at volume 3, tab 37, electronic folder page 2173. So nobody disputes that such provision is within the legislative competence of the Scottish Parliament. In relation to the Act, dealing quickly with the provisions that are relevant, Section 1 relates to scope, Section 2 to the questions that are posed in the referendum, 4 deals with the eligibility of those who are entitled to vote, and Section 6 and Schedule 1 make detailed provision about the manner of voting, such as absent or postal votes and registration. So that having been encapsulated within the Referendums Scotland Act 2020, the proposed bill is in fact relatively short, and we can see that at page EF13 of the electronic bundle. So the bill itself begins by narrating the purpose of the legislation under Section 1 to make provision for ascertaining the views of the people of Scotland on whether Scotland should be an independent country. Provision is then made for the question to be posed, the ballot paper, and the date of the referendum. That's dealt with in Section 2, and the franchise is contained in Section 3. The question in the proposed bill is the same question that was posed in the 2014 referendum. The 2020 Act is then applied, although any specific qualifications are yet to be identified, and the standard final form of provisions are to be included in paragraphs 5 through to sections 5 through to 8. The form of ballot paper is set out in the schedule, and notably, no provision is made for the effect of any result of the referendum. That is, the referendum is not self-executing, it simply produces a result. So no legal consequences automatically or necessarily flow from any result. This is a draft bill. It has not yet been introduced, but it is in final form with the exception of immaterial details. It is in the form that I, as Lord Advocate, would be asked to provide advice to the Scottish Government on as to whether or not it is within competence. The Advocate General has drawn attention to the fact that there are presently no accompanying documents, such as draft explanatory memoranda. That is true, but my consideration of a draft bill is not always informed by such documents. When such documents are available, indeed they're not always in final form. In any event, the bill is obviously very short and straightforward. Its purpose is set out in the terms of the bill itself, and it is in materially the same terms as that which was authorised in the 2014 referendum. So looking then to the relevant legal framework and the powers of the Scottish Parliament, there is a body of case law concerning the interpretation and application of some of the central aspects of the Scotland Act. The Scotland Act introduced a fundamental change to the constitutional structure of the United Kingdom. Sections 1 to 12 of the Act constituted the Scottish Parliament as democratically elected legislature among whom members of the Scottish ministers are drawn to form the Scottish Government. Scottish ministers are drawn along with Scottish law officers to form the government, and to which those ministers and law officers are accountable. The creation of the Scottish Parliament and the nature of it was referred to by Lord Hope in the case of BH against Lord Advocate, and that the reference I would wish to make there is at paragraph 30. I don't need to turn up the authority, it's at EF 3154, tab 53 of the authorities, and he said the fundamental constitutional nature of the settlement that was achieved by the Scotland Act, is how you refer to it, and all members of the court agreed with this part of his judgment. In AXA, the president of this court, Lord Reid, at paragraph 153, which is authority 4, EF 517, explained, quoting Lord Roger in R against HMA, paragraph 16, that the Scotland Act is a major constitutional measure which altered the government of the United Kingdom. The status of the Scottish Parliament was described by the President, Lord Reid, in the UNCRC Bill reference at paragraph 7. At EF 904, at 911, authority tab 15, he said this: the Scottish Parliament is a democratically elected legislature with a mandate to make laws for Scotland. It has plenary powers within the limits of its legislative competence, but it does not enjoy the sovereignty of the Crown in Parliament. Rules delimiting its legislative competence are found in section 29 and of schedules 4 and 5 to the Scotland Act, to which the courts must give effect. And Parliament also has an unlimited power to make laws for Scotland, a power which the legislation of the Scottish Parliament cannot effect. Section 28(7) of the Scotland Act. The Scotland Act must be interpreted in the same way as any other statute. The courts have regard to its aims to achieve a constitutional settlement and therefore recognise the importance of giving the Scotland Act a consistent and predictable interpretation, so that the Scottish Parliament has a coherent, stable and workable system within which to exercise its legislative power. That is achieved by interpreting the rules as to competence in the Scotland Act according to the ordinary meaning of the words used. In AXA against General Insurance Company against the Lord Advocate, 2011, at paragraph 146, again Lord Reid, at electronic folder page 515, emphasised not only the breadth of the Scottish Parliament's plenary powers, but also that it's for the Scottish Parliament to determine the political and other considerations that it wishes to take account in exercising its plenary powers. Lord Reid said, within the limits set by section 29(2), However, its power to legislate is as ample as it could possibly be. There is no indication in the Scotland Act of any specific purposes which are to guide it in its lawmaking, or any specific matters to which it is to have regard. Even if it may be said at the highest level of generality that the Scotland Act, Scottish Parliament's power had been conferred upon it for the purpose of good government of Scotland, that would not limit its powers. Lord Reid said the Act leaves it to the Scottish Parliament itself, as a democratically elected legislature, to determine its own policy goals. It has to decide for itself the purposes for which its legislative powers should be used, and the political and other considerations which are relevant to the exercise of those powers. So the limits on legislative competence of the Scottish Parliament are set down in section 29A of the Scotland Act. And while there are common law limits to the legislative competence of the Parliament, which were referred to in the case of AXA at paragraph 153 by Lord Reid, those limits are not relevant for present purposes. But turning up section 29, which is in Authorities tab 1, EF page 129, the section 29 provides, so far as relevant for present purposes, in subsection 1, that an Act of the Scottish Parliament is not law so far as any provisions of the Act is outside the legislative competence of the Parliament. A provision is outside that legislative competence so far as any of the following paragraphs apply, and that is B, it relates to reserved matters. At subparagraph 3, the section 29 goes on to state, for the purposes of this section, the question whether a provision of an Act of the Scottish Parliament relates to a reserved matter is to be determined, subject to subsection 4, by reference to the purpose of the provision, having regard, among other things, to its effect in all the circumstances. In subparagraph 4, it provides a provision which would otherwise not relate to reserved matters, but which makes modifications of Scots private law or Scots criminal law as it applies to reserved matters, is to be treated as relating to reserved matters until the purpose of the provision is to make the law in question apply consistently to reserved matters or otherwise. And at subsection 5 it says subsection 1 is subject to section 30, subsection 6. So the statutory concept of relates to is thus afforded a specific legal definition from and more restrictive than its ordinary meaning. And I'll address the case law on that term, the term of relates to, in due course. Section 31, which is over the page at EF 131.
So where do you get that point from section 29, that the term relates to, or the concept relates to, has a special meaning?
Yes. So, my lady, I read it in terms of the provision, but also I get that from case law that I'll come on to refer to.
But were you saying that comes from subsection 4? Is that what?
Subsection 3, I said. So, for the purposes of this section...
We're not concerned with subsection 4 in this.
No, we're not concerned with 4.
But subsection 3 is...
Yes, that's exactly right. We're concerned with 3.
Oh, I see.
Yes. So, just to say that the question of... The subsection 3 says, for the purposes of this section, a question whether a provision of an Act of the Scottish Parliament relates to a reserved matter is to be determined subject to subsection 4 by reference to the purpose of the provision, having regard, among other things, to its effect in all the circumstances. And I think that's been described as a term of art in later cases where the court has looked extensively at the meaning of relates to in the Scotland Act. In relation to section 30, subsection 1, that gives effect to Schedule 5, and I was looking at that. and it says, so section 30 says that it's headed legislative competence, and section 30 subsection 1 explains that Schedule 5, which defines reserved matters, shall have effect. And for present purposes, the relevant reservations are found in paragraph 1 of Schedule 5. And Schedule 5 is at EF 184. And provides as follows in paragraph 1, EF 183 to 184, paragraph 1's at 183. So paragraph 1 says the following aspects of the Constitution are reserved. At 1B, the union of the kingdoms of Scotland and England, and 1C, the Parliament of the United Kingdom. And I'd simply emphasise from looking at this the following points. The Constitution itself is not a reserved matter. The Constitution simpliciter is not reserved. It's only specified aspects of that. And the language used in 1B reserves the union of the kingdoms of Scotland and England. And I've noted in the written case at paragraph 100 to 102 that there is a peculiarity in that the kingdoms of Scotland and England have been superseded by the United Kingdom of Great Britain and Northern Ireland. And 1C refers to the Parliament of the UK, but I don't suggest anything turned on that, just a particular peculiarity of the legislation. So in relation to the case law on relates to, the approach to the term relates to was summarised by this court in its judgment, the UK withdrawal from the European Union Legal Continuity Scotland Bill case 2018 at paragraph 27. It's authority 11 at EF page 836, and I think it's helpful to look at paragraph 27 of the Continuity Bill case. So paragraph 27 is at page EF 835 and on to page EF 836. And it provides, the court said at paragraph 27, in order to relate to a reserved matter, a provision of a Scottish bill must have more than a loose or consequential connection with it. And references there made to Martin against Most, Lord Walker, at paragraph 49, and to the Imperial Tobacco against Lord Advocate case, 2012, at paragraph 26. It said that Lord Hope observed that the question required, 1, first to understand the scope of the matter, which was reserved, and secondly, to determine by reference to the purpose of the provisions under challenge, having regard, among other things, to their effect in all the circumstance, whether those provisions relate to the reserved matter. The purpose of an enactment for this purpose may extend beyond its legal effect, but it is not the same thing as its political motivation. So in paragraph 27, the reference was made to relates to means more than a loose and consequential connection, citing Martin against Most, and that the question requires first to understand the nature of the matter which is reserved, and second, to determine by reference to the purpose of the provision, having regard to its effect, whether the provision relates to a reserved matter. The purpose may extend beyond legal effect, but is not the same as political motivation. So, whilst that is the general framework, I submit that taking the case law as a whole, there is doubt about two matters. The precise relevance of connection to the statutory test set out in section 29.3. So the precise relevance of connection. And secondly, the nature and degree of the connection that must exist before the possibility arises that a provision relates to a reserved matter.
This is really all stemming from the, well, in fact, it is entirely Lord Mance's judgment in the Welsh case, isn't it?
It is in part relating to Lord Mance's judgment, but I also, to demonstrate that he's not in any sense an outlier, actually would make reference to what my Lord said in the Inner House in Imperial Tobacco. In fact, I think consistent with what Lord Mance's approach was, and indeed what Lord Brodie said in the Inner House in the Imperial Tobacco case. Because I think when you compare what was said by my Lord in the Inner House in Imperial Tobacco to what was eventually determined by this court, in which Lord Hope gave the judgment, there's very little difference to draw between what my Lord said there and what was ultimately determined. So
Lord Advocate, I think there may be an issue between you and Sir James in relation to whether Lord Mance,
yes,
in the Welsh asbestos case, was actually supporting a test of direct connection.
yes, that's exactly so. So I'm going to come on to deal with that. Yes, but my point is that Lord Mance is in no sense an outlier in that regard, and we can see that what he said is consistent with what my Lord just said in the Inner House and Imperial Tobacco, but also consistent with the way in which this court determined the Continuity Bill case and the underlying ratio and the underlying rationale for the determination in the Legal Continuity Bill case. So just dealing with that point then. The starting point, I would suggest, is Martin against Most, which was determined in 2010. And that's in the authorities at tab 3, electronic folder, page 382, and at paragraphs 404 to 405. Lord Walker there referred to the difficulties of defining necessarily in fairly general and abstract terms permitted or prohibited areas of legislative activity, and how forms of words have come to be recognised as indicating a more or less proximate or direct or crucial connection between a proposed enactment and an area of legislative activity. At paragraph 49, electronic folder, page 406 to 407, Lord Walker said that relates to suggests more than a loose and consequential connection, and that the reference to purpose reinforces that. Here the word connection appears to be used as simply shorthand for and not separate from or additional to the statutory test of relates to imposed by the relevant devolution legislation. So the effect of 29.3 that we've looked at is that the purpose of a legislative instrument that must relate to a reserved matter, it's the purpose that must relate to the reserved matter. It's therefore necessary to identify the purpose with precision. The second aspect of 29.3 is that it requires a particular attention to effect. That is not a separate test, but essentially it's mandating that the purpose is derived with particular attention to the effect of a provision, essentially what powers, duties and rights it confers. So the fact that the purpose of the legislation is central to the question whether the legislation relates to a reserved matter was made clear by Lord Hope in Imperial Tobacco at paragraph 16, and we see that at electronic folder pages 631 and 640. At paragraph 16, Lord Hope said, "It will, of course, be necessary to identify the purpose of the provision if the challenge is brought under section 29.2b on the ground that it relates to a reserved matter, bearing in mind that the phrase relates to indicates something more than a loose or consequential connection. That's also what was said in the same terms, similar terms, in the Christian Institute case, which is at tab 10, at paragraph 30, which is at electronic folder page 791. So just looking at the Christian Institute case, tab 10, paragraph 30, EF 791. There the court said, whether a provision relates to a reserved matter in the sense explained by Lord Walker is determined by reference to the purpose of the provision in question. That purpose is to be ascertained having regard to the effect of the provision among relevant matters. As was said in relation to similar provisions in the Government of Wales Act 2006 in Attorney General for England and Wales against Counsel General for Wales, paragraph 50, as section 50 requires the purpose of the provision to be examined, it is necessary to look not merely at what can be discerned from an objective consideration of the effect of its terms. So that case didn't provide further guidance on the nature or degree of connection that must exist between a reserved matter and the purpose of a provision before it can be said that the provision relates to the reserved matter. That was, as I say, done in the case in re medical costs for asbestos diseases Wales Bill case 2015, UK Supreme Court, Authority tab 9, electronic folder page 716, and that authority is also in volume 1. The asbestos case, the medical cost for asbestos diseases Wales Bill case, was designed to impose liabilities on persons compensating victims of asbestos-related disease and their insurers for NHS costs. It was designed to compensate NHS Wales for the costs of asbestos disease. The key question was whether the Government of Wales Act provided legislative competence. And at that time, the Act operated on a conferred powers model rather than a retained powers model. And the then Welsh Assembly only had the powers expressly conferred on it. And one of the competencies conferred was the organisation and funding of the National Health Service. The Government of Wales Act permitted legislation to be made by the Assembly that related to a conferred power, and the relevant statutory provisions are set out in paragraphs 11 and 12 of the case at electronic folders 728 to 729, and that's in volume 1, tab 9. So the paragraphs are 11 and 12, 728 to 729 of the electronic folder. It is helpful just to quickly look at the statutory provisions because they do assist in understanding the basis upon which the court decided the case. 728 then. So the heading is competence under section 108.4.5, paragraph 11, and then over the page it says that under section 108.3, a provision is only within the legislative competence if it falls within section 4 or 5, and the provision falls within section 108.4 if it relates to one of the subjects listed under any of the headings in part 1 of Schedule 7 and doesn't fall within any of the exceptions specified in that part of the schedule. A provision falls within section 108.5 if it provides for the enforcement of a provision of that section 4 or a provision of an assembly measure, or it's otherwise appropriate for making a provision effective, or it's otherwise incidental to or consequential on such a provision. The relevant matter was specified in Part 1 of Schedule 7, and it was placed under heading Health and Health Services, and the specific competence conferred is listed there, and it ends in, where it begins, promotion of health, a long series of areas in which conferred competence is given, summarised at the end by organisation, funding of the National Health Service. There are exceptions that are listed also under the heading Health and Health Services that are listed also in paragraph 12 of the decided case.
And is there a provision similar to section 29, subsection 3?
Yes, that's right. There is, yes. So I have that particular reference to say paragraph 25, I think Lord Mans deals with that. Yeah. He says that section 1087 provides that for the purposes of this section, the question whether a provision of an Act of the Assembly relates to one or more of the subjects listed in Part 1 of Schedule 7 or falls within any of the exceptions specified is to be determined by reference to the purpose of the provision, having regard, among other things, to its effect in all the circumstances. And I think he says that the way in which it has to be approached in relation to Wales Act is exactly the same way it should be approached in relation to the Scottish provision. So, at paragraph 24, Lord Mans described the key question, which is on page 734, is whether, on the assumption I'm making, the Government of Wales Act provides legislative competence for the imposition of liabilities on compensators and insurers, and to this I therefore turn. I've already touched on what he dealt with at paragraph 25, and what the majority of this court therefore made clear is that the approach under the Government of Wales Act should be identical to that taken under the Scotland Act. We know, though, as a result of the 2017 Wales Act, they moved from a conferred powers model to a reserved powers model. So in this case, Lord Mans, in paragraph 25, cites the Imperial Tobacco case and the comments by Lord Walker in Martin against Most that we've already looked at. And then, since it was clear that the purpose of the legislation in issue was to reimburse the NHS, the critical question or critical issue was whether this sufficiently closely related to funding the NHS. Was it sufficiently close to the conferred power granted? The specific provisions in the bill which imposed liabilities on compensators and insurers was then assessed according to the propositions set out by Lord Mans in his assessment of what the meaning of the conferred power was. And he concluded at paragraph 26 that the operation and funding of the NHS clearly cannot permit general money raising, and hypothecation for the NHS is in substance no different from a general charge boosting the Welsh Government's resources, and doesn't change the conclusion in one. And he also noted at paragraph 28 that the Welsh ministers couldn't raise money in any way they chose, even if the only purpose for which the money is raised could be the Welsh NHS. He said to come within competence, any money raising would have to be, and this is in paragraph 27, more directly connected with the service provided and its funding. And simply raising money which can be used to fund the NHS could not constitute a sufficiently close connection, compared to, for example, in this case, the direct connection of a prescription charge. So Lord Mans therefore concluded that in this case of the charges posed, including those within section 2 of the bill that the court was concerned with, the argument would have to be that a sufficient connection could be found in the actual or alleged wrongdoing that led to a compensator making a compensation payment to or in respect of a sufferer from an asbestos-related disease. In this case, he explained that this could only be an indirect, loose or consequential connection.
He's evidently adopting Lord Walker's language and using those words.
That's right, yes. So I say this about the reasoning of Lord Mance in these paragraphs. I say it is directed to the degree or closeness of the connection between the purpose and effect of the legislation and the matter of funding the NHS. Lord Mance reasoned that the purpose was not sufficiently close to the funding of the NHS, and it was only indirectly related to the funding of the NHS. For that reason, he said legislation was not within competence. And so, in relation to Lord Mance, I say, at one end of the spectrum was a law which had the purpose and effect of raising money to cover the costs of the NHS, perhaps a law unrelated to health. This, Lord Mance explained, could not constitute a sufficiently close connection to funding the NHS. And at the other end of the spectrum were prescription charges, where there is a direct connection to benefiting from a service and contributing to its funding. I say that it's clear that Lord Mance was directly concerned with the closeness of connection and whether it was direct or indirect. And Lord Mance then turned to the facts of the case and asked whether a law targeting compensators and insurers is sufficiently closely related to funding the NHS service. And he referred to the fact that here there is the wrongdoing relating to asbestos disease. However, in the critical part of his reasoning, he stated that that is at best an indirect, loose or consequential connection. In this sentence, he very deliberately and expressly modifies Lord Walker's language to emphasise the need for a direct connection and to exclude a consequential connection. That this was the crux of the reasoning is clear not only from the paragraphs in the preceding paragraph in 27, but also from the following sentence, where he refers to persons having no other direct connection in law with the NHS. So I say, therefore, that the Welsh asbestos case held that the connection between the purpose of a measure and, in that case, a conferred power must be close and direct. It's not sufficient that its general aim or subject matter concerns the subject matter of a conferred power. The Welsh asbestos law concerned funding the NHS in the sense that it would raise money for the NHS, but that was insufficiently directly related to the conferred power of organisation and funding of the National Health Service. I say not only is this requirement for directness relevant to the issue as to whether an advisory referendum is related to union, but it also provides an illustration of a case where it was not sufficient that the law was concerned with the same subject matter but lacked direct connection. So the Advocate General at paragraph 59 in his submission submits that the case does not purport to create any different approach from imperial tobacco, and nothing in the judgment of Lord Mance indicates that a requirement of direct connection is imposed. But I say that is not right for a number of reasons. I see it's just after 1 o'clock.
Shall we come to those after the short adjournment?
Yes, thank you, Lord.
Very well, 2 o'clock.
just before lunch, I had moved on to the Advocate General's submission at paragraph 59 of his case, at page EF 107, where he'd submitted that the Welsh asbestos case hadn't purported to create any different approach from Imperial Tobacco, and said that nothing in the judgment indicated that a requirement of direct connection is imposed. My position is that is not correct. Lord Mann's expressly reformulated words used in Martin against Most to include a requirement of directness. He didn't disagree with Lord Walker and Lord Hope that a loose and consequential connection would not be sufficient, but he and the majority of this court held that this was not an exhaustive description of circumstances in which a law will relate to a designated matter. I say that his reasoning and the ratio of the case turned on the fact that the purpose and effect of the Welsh law was not closely and directly related to a conferred competence. Indeed, it is not difficult to see why directness was at the heart of the reasoning, given the difficulty characterising the law as only loosely or consequentially related to funding the NHS. And finally, the Advocate General complained that Lord Mance's words are taken out of context. I would say they are not. Their context reinforces the view that directness and closeness were highly important in determining whether the law related to the funding of health services in Wales. Moreover, I say there's no reason to suggest that Lord Mance's reference to directness cannot be taken from the context of the case than there is to take Lord Walker's references to loose and consequential from the context of that particular case. And I would point out that Lord Mance's approach to the use of directness is entirely consistent with that expressed by President Lord Reid when he sat in the Inner House in the Imperial Tobacco case. And it's also consistent with what Lord Brodie said in his speech also. The Imperial Tobacco case in the Inner House is in tab 5 of the first volume of Authorities, and Lord Reid's speech is at page EF 588. That's the part where he starts to deal with section 29 of the Scotland Act. Lord Reid begins by referring to Lord Walker at paragraph 119, and thereafter at paragraph 120 explains that the relevant rules are contained in a number of provisions in the Scotland Act and make specific reference to section 29. And he says it's necessary at this point to consider section 29(2)(b) and 3. As I have explained, section 29(2) states that a provision is outside the competence of the Scottish Parliament if it relates to reserved matters. And he quotes again from Martin against Most at paragraph 49. Thereafter, Lord Reid says, I respectfully agree. In ordinary English, relates to does not mean the same as affects, and although it is a wide expression, it cannot be intended to give such wide construction as to invalidate all legislation affecting matters listed in Schedule 5, however slight, indirect, or remote the effect may be. The practical considerations which led to that conclusion in the case law relating to Canada, Australia, and Northern Ireland are equally cogent in the context of the Scotland Act. At paragraph 121, he went on to say, deciding whether legislation relates to a reserved matter involves two stages. First, determining the meaning of the words defining the reserved matter, and secondly, determining whether the legislation relates to that matter. At the first stage, it is to be noted that the Scotland Act doesn't adopt a double enumeration model, but defines the Scottish Parliament's powers by implication, as what remains once reserved matters have been excluded. it follows that, unlike the position in Canada, the interpretation of the reserved matters should not reflect any assumption as to the extent of matters which are not reserved.
This is all, I mean, I remember this coming back to this is quite an early case, and it's against the background of arguments where people were trying to rely on authorities and approaches adopted in other jurisdictions,
That's right.
such as Canada and Australia and indeed Ireland. And I think we were trying to explain how the position under the Scotland Act differed from those under other schemes.
Yes, so that's certainly what my Lord is dealing with there at 121, but I think it is important to look to what he said immediately before that, which is that in ordinary English, relates to doesn't mean the same as affects, and although it's wide, it can't be intended to give a wide construction as to invalidate all legislation affecting matters listed in Schedule 5. And the words my Lord used are, however slight, indirect or remote the effect may be. And certainly the issue about how you deal with the Scottish legislation against the background of the position in Canada and Australia was relevant. But what my Lord went on to say in paragraph 123 was this, that Schedule 5 listed matters, not purposes. Since the question whether a provision relates to a reserved matter is to be determined, read short, by reference to its purpose, it appears that the purpose of a provision is to be treated as a pointer to the matter to which it relates. Once the purpose of the provision has been identified, therefore the remaining question is whether the matter to which it points is within the scope of the reserved matters listed in Schedule 5. That question may be straightforward, or it may be more complex depending on the circumstances. At 125, my Lord then went on to say, as Lord Roger observed in Martin against Most, the purpose of a provision will often be clear from its context in the Act in question. The Court can also consider extrinsic material which is relevant to ascertaining the purposes which the provision enacted to achieve. As Lord Hope indicated at paragraph 25, the Court is also expressly required to have regard to the effect of the provision. But what I think is important is when we go over to paragraph 133, we see how my Lord brings all of that together. And if I take my Lord to that, in the context of the Imperial Tobacco case that dealt with the display of tobacco products and the effort made by the legislature to reduce the attractiveness of these to children, at 133 my Lord said this, I've set out the terms of Section 1. It begins by prohibiting the display of tobacco products in places where such products are sold, subject to a discretion conferred on the Scottish ministers by subsection 4, to provide that no offence is committed by a display which complies with prescribed requirements. It then provides a limited exception in respect of tobacconists, subsection 2, again subject to compliance with any requirements which may be prescribed by the Scottish ministers. It also provides a general exception in respect of wholesalers, and again subject to compliance with any requirements which may be prescribed by the Scottish ministers. My Lord said the legal effect of Section 1 is therefore to establish a statutory basis for the regulation by Scottish ministers of the display of tobacco products in places where such products are sold. Its short-term practical consequences will depend, in the first instance, upon how Scottish ministers exercise their regulatory powers. The Court is not equipped to predict the ultimate long-term effects of the provision, nor does it require to do so in order to identify the purpose of Section 1. The extrinsic material indicates that the purpose of Section 1 was to enable Scottish ministers to take steps which might render tobacco products less visible to potential consumers and thereby achieve the reduction in sales and thus in smoking. The legal effect is consistent with that purpose. So I say, my Lord here, specifically in his speech and in his analysis, drew the attention to the requirement of directness as an element of the test. And that's also consistent just with a small part of what my Lord said in paragraph 124.
What I was addressing in 133 was it set out in 132, it was the argument that the purpose of the provisions was the protection of health. I mean, this was effectively restrictions on the display of cigarettes, and that the purpose was the protection of health, which was a reserved matter. And the approach I took to it, as you've just shown, was to say, well, was to look at more immediate purposes rather than an ultimate purpose, which who knows whether or not it would be achieved.
Yes, I understand that from my Lord's reasoning. But what's interesting is certainly the attention to detail and the need to understand whether it was more than an incidental or indirect effect. And that was really something that my Lord also touched on when he was dealing with a slightly different matter in paragraph 124. Because in that paragraph, my Lord was dealing with a situation where a provision is enacted to achieve a number of objectives, and it might relate to more than just one matter that's reserved. I think the language my Lord used here is also important. So I think in 124, my Lord was saying in particular, although section 29.3 refers to the purpose of the provision in the singular, in real life legislation may be enacted in order to achieve a number of objectives. In such a situation, it may be unrealistic to regard a provision as relating only to a single matter, and it's possible that in such a situation, one of the matters to which it relates may be reserved, and another may not. And at that point, my Lord borrowed the hypothetical example given by Lord Roger in Martin against Most, and it was a very obvious example of where simultaneously one might be dealing with a devolved and reserved matter. I don't need to go into that. Goes on to say this though, unlike the position in Canada, where legislation must be characterised as relating to only one predominant matter in order to avoid a conflict between the two lists, it may be arguable that the court is not driven by the logic of the Scotland Act to follow that approach. I would therefore wish to reserve my opinion as to the correctness of the argument of counsel for the respondent, that even if the provisions in issue relate in more than a merely incidental or indirect manner to the regulation of the sale of goods to consumers, they are nevertheless within devolved competence because their predominant purpose is the protection of health. Now, we're looking at a slightly different aspect here, but again, my Lord turns to looking at this language of incidental or indirect, and that's exactly how Lord Mance approached the issue in the Welsh Asbestos Case. He was looking for a directness as an element to the test, and I think that's also consistent with what Lord Brodie said at page EF 623 to 624 at paragraph 202. It's really at the bottom of that paragraph, at the bottom of page 623, when he's dealing with the provision that relates to reserved matters. And at the bottom of 623, he said, a provision may, and indeed probably will, have a variety of effects, some more remote than others. In such a case, it is the more proximate or direct or crucial effect that's of importance. Incidental effects are to be disregarded. As was put in the passage from W&A MacArthur Limited against Queensland, quoted by Lord Walker in his opinion in Martin against Most, we have to determine in each case what is the subject of the legislation, what the subject of the Act with respect to, what it affects, not things or operations it may indirectly affect. So that I say that rather than Lord Mance's approach being an outlier or inconsistent with that expressed by others. It's entirely consistent with what his approach is entirely consistent with the way in which my Lord and Lord Brodie approached the matter in the Imperial Tobacco case in the Inner House. There was no criticism of this approach at all by Lord Hope in the House of Lords, and it's important to have regard to when we think about the way in which we approach the reservations in the Scotland Act and just how we deal with the question of the subject matter, whether or not it concerns subject matter of a devolved or reserved power. So I say that further consideration to this particular issue was given by this court in the Continuity Bill case. That's authority at tab 11, volume 1, and at EF 822. And that was a case in which this court held that a bill of the Scottish Parliament would only relate to the reserved matter of international relations if, by its terms, it sought to disrupt or interfere with the conduct of international relations by the UK government. The court stated that there is relatively little scope for Scottish legislation to relate to international relations unless such legislation were to purport to deal with the power of ministers of the Crown to exercise its prerogative in foreign affairs or create a state of law in Scotland which affected the effectual exercise of that power. And that's at paragraph 32 of that decision. It's also, I'll just get the page, EF 837. I think it's also helpful, though, to look at paragraph 33 of that judgment. So, 837. Yeah. So I quoted there in paragraph 30, but then in paragraph 33, it's very helpful to look there at what the court lists in relation to the proposed legislation that does or does not have the necessary connection or effect. And it says at paragraph 33, in our judgment, the Scottish Bill does not relate to relations with the EU. It will take effect at a time when there will be no legal relations with the EU unless a further treaty is made with the EU. And then lists the things that the bill doesn't do. The Scottish Bill does not purport to deal with any legal rule affecting the power of ministers of the Crown to negotiate such a treaty, or otherwise to conduct the UK's relations with the EU. It doesn't purport to affect the way in which current negotiations between the UK and the EU are conducted. It simply regulates the legal consequences in Scotland of the cessation of EU law as a source of domestic law relating to devolved matters, which will result from the withdrawal from the EU already authorised by the UK Parliament. This is something the Scottish Parliament is competent to do, provided that it does so consistently with the powers reserved in the Scotland Act to the UK Parliament and with legislation and rules of law protected under Schedule 4, and 2, that its legislation does not relate to other reserved matters. Parts of the argument of the UK law officers appear to suggest a wider objection that separate Scottish legislation about the consequences of withdrawal is legally untidy, politically inconvenient, or redundant in the light of corresponding UK legislation. But we are not concerned with supposed objections of this kind, which go to the wisdom of the legislation and not its competence. So the court in continuity, the court's reasoning in continuity placed considerable emphasis on the need for there to be some form of practical or legal effect or impact of the law on the reserved matter. That is entirely consistent and in accordance with the approach taken in the Welsh asbestos case and with the same way in which my Lord approached matters in the Imperial Tobacco case. And I say it's implicit in the reasoning of the court in the legal continuity reference that from that it's reasonable to suggest that holding an advisory referendum on an issue of international affairs would not relate to a reserved matter by the Scottish Parliament. The Advocate General objects that in my written case I didn't relevantly address the Christian Institute case. But that case, I say, doesn't assist in the submissions made by the Advocate General on this point. The case is at EF 771, Authority Tab 10, Volume 1. For the purposes of this reference...
What was the page number again, sorry?
EF 771.
Thank you very much indeed, thank you.
Tab 10 in Volume 1. For the purposes of this reference, the relevant issue in the Christian Institute case was whether data sharing provisions in Part 4 of the Children and Young People Scotland Act, which made provision for a named person service to young people, were outside the competence because they related to the Data Protective Directive, which was reserved to the UK Parliament. The Act created a duty to share information about the well-being of children, which did not depend on the consideration of whether it would have been objectively relevant or necessary for that information to be shared. And that's paragraph 16, page EF 778. The court found that although there was a bespoke regime of data processing under the Children and Young People Act 2014, it didn't relate to the Data Protection Act or the Data Protection Directive, the subject matter of which was specifically reserved, because it was not truly distinct from the overall purpose of promoting the well-being of children. You can find that in paragraph 64 to 66, EF 805. This case then, the Christian Institute case, turned on an identification of the core purpose of the legislation, and provisions in relation to data sharing were not to be treated as being distinct from the core purpose. There is, however, nothing in that reasoning that affects the points that I have made. It's true that the Christian Institute case is the Martin against most phraseology that's used and said to represent a well-established approach. You can see that in paragraph 63 on the last line and paragraph 29 at EF 791. But the additional facet introduced by the Welsh asbestos case was not addressed or apparently identified by the court. So, on the basis of these authorities, in my submission, it would seem that a matter will only relate to a reserved matter within the meaning of section 29(2)(b in circumstances where its purpose is directly and closely related to a reserved matter, probably in this context requiring some actual practical effect, such as imposing some practical restriction or impediment on the pursuit of a reserved matter with an indirect, loose or consequential connection being insufficient. So I now turn to the arguments for the proposition that Section 2 relates to the Union before turning to the arguments against that proposition and for the alternative, that is, that Section 2 would not, by virtue of the reservation in paragraph 1b of Schedule 5, be beyond the legislative competence of the Scottish Parliament. The argument that the referred provisions of the proposed bill relate to the Union I can take reasonably briefly, given that the Advocate General has set out the case in detail and maintains that this is the correct analysis of the law. I say there's no real difficulty as to what the reserved matter means. Whilst I noted the incongruity in the statute referring to the union of England and Scotland rather than the union of the United Kingdom, including Northern Ireland, nothing turns on this. The union is a legal union between what were formerly, politically and legally independent kingdoms. The purpose of this being reserved is equally clear. The purpose of the provisions in paragraph 1 of Schedule 5 in reserving matters relating to certain aspects of the Constitution is that the matters in which the United Kingdom as a whole has an interest should continue to be the responsibility of the UK Parliament at Westminster. And the relevant authorities that I would refer to in that regard are Imperial Tobacco at paragraph 29, Lord Hope of Craighead, with whom the other members of the court agreed. That's at page 645. And that was the point repeated in the Christian Institute case, where again Lord Reid said a similar thing at paragraph 65. Again in authorities at page EP 805. The different arguments turn not on any difference of view or uncertainty as to the meaning of the union. Rather, they turn on what it means for legislation to relate to the union. The argument against competence has essentially 5 elements. The first is this: the subject matter of the referendum question, asking whether Scotland should be an independent country, concerns the unions of the kingdoms of Scotland and England. The question asks voters to express their opinion on whether they want the union to continue. That, however, does not resolve the issue, just as it didn't resolve the issue in Christian Institute case, that the subject matter of the provisions in question was data protection. The subject matter in the provisions in the Welsh asbestos case was raising money for the health service. And as the court explained in legal continuity case, legislation relating to international relations would not by dint of its subject matter alone relate to the reserved matter of international relations. Secondly, as we've seen, there have been a number of judicial statements in this court to the effect that a provision will relate to a reserved matter where the purpose of the provision has a more than loose and consequential connection to it. Again, referring to there, Martin against Most at paragraph 49, Lord Walker on page of the electronic bundle of 406, Imperial Tobacco, paragraph 16, Lord Cope at EP 640, and the Legal Continuity Bill, paragraph 27, again electronic number 835, and also to the earlier arguments I made before in relation to legal continuity at paragraph 33.
I see you referred us a moment ago to paragraph 65 of Christian Institute.
Yes. Yes, I think that's it.
Just looking at that, the first sentence may be of some relevance.
Yes. I'll just get that one, Lord.
It's on page 805.
Yes. And my Lord said the first...
the first sentence struck me as possibly being of some significance if we're trying to apply these provisions about reserved matters.
Yes, so there it says it's important to bear in mind the central aim of the provisions in the Scotland Act concerning reserved matters, explained in paragraph 28, that matters in which the UK has a whole interest should continue to be the responsibility of the UK Parliament. Yeah. That's right.
Yeah.
Yeah.
So the Union and Parliament itself are obviously examples.
I'm so sorry, my Lord.
So the matters listed in Schedule 5, such as the Union and the Parliament of the UK, are are obviously examples of matters in which the UK as a whole has an interest.
Yes, I see that, Lord. And I suppose it's the question, and I'll come on to talk about this a little later, is whether or not legislating about the Union is enough to meet the relates to test when the referendum is about a matter that's reserved. I think that it might be relevant to think that's the intention of the UK Parliament in creating reserved matters is not to be taken to prevent the Scottish Parliament asking the people of Scotland about matters of importance to the Scottish people, even if reserved. It might be thought that the intention of the constitutional arrangement reflected in the Scotland Act was to prevent the Scottish Parliament unilaterally changing law and matters that are the responsibility of the UK as a whole. And the important thing would be to question whether or not the case law points to the need for some sort of direct rather than consequential practical effect. So if we have simply an advisory referendum, we're not actually taking out of the UK as a whole the step that would be necessary to give effect to the outcome of any advisory referendum. I think that's the important issue that might be raised in connection with the undoubted statement about the purpose of the reservations and the protection of the integrity of the UK Parliament. So I was dealing with the arguments against competence, and the third one that I would point to is that although the immediate purpose or direct object of the proposed bill is simply to ascertain the wishes of the Scottish electorate on the question of independence, a wide variety of background materials, which are admissible aids to identifying the purpose of legal provision, and refer to Martin against Most at paragraph 25 there, electronic folder page 397, that establishes that this is intended by the Scottish Government to be a step towards independence from the United Kingdom. So the background materials certainly identify the purpose of a legal provision, and that's relevant here. Thus, the argument is that the bill is intended to fulfil a manifesto commitment of the Scottish Government, which stated that the SNP was clear that the referendum must be capable of bringing about independence. And that's reflected in the SNP manifesto, which we have lodged, and it's at page EF 6361, tab 112 in volume 9.
Again, I'm terribly sorry. What was the page number again?
6361.
Thank you.
It's the SNP Manifesto, Scotland's Future, Scotland's Choice, 2021, and the reference is page 12 in that document. And also the Scottish Government's Programme for Government 2021 to 2022 likewise refers to the Scottish Government obtaining a democratic mandate from the people of Scotland to pursue the opportunity of being an independent country. And that's reflected in the First Minister's foreword in the Programme for Government 2021 to 2022 at pages 6426 and through to 6430. Fourthly, as to effect, the proposed bill would have the legal effect, among other things, of authorising election officials to administer a vote and allocating resources to them to do so on whether the union should end. It is therefore arguable that it's not devoid of any legal consequences. Fifthly, although the referendum would have no legal effect on the union, the practical effect of a vote would be politically significant. That point was recognised by the majority in Miller at paragraph 124, which is in volume 5 of the Authorities, number 57, and it said that whilst the referendum leaving the EU had no legal effects, that way in no means in no way means it's devoid of effect. And the page number there is 3429 in relation to that quote. Indeed, the case went on to say, on the contrary, it was said to be of great political significance. At paragraph 125 of Miller, this court quotes from the House of Lords Constitution Committee in its 12th report, 2009-10, Referendums in the UK, House of Lords paper 99, stated that even where a referendum is advisory only, it would be difficult for Parliament to ignore a decisive expression of public opinion. And that quote comes from page 5900 in the electronic bundle and is at paragraph 197 of the House of Lords Committee report. So taking these points together, there is a clear and cogent argument that the Scottish Parliament doesn't have the power to enact a law providing for an independence referendum. The Union is a matter in which the whole of the United Kingdom has an interest and for which the UK Parliament retains primary constitutional responsibility. A referendum on Scottish independence would have more than a loose or consequential connection with the reserved matter of the Union, because the purpose of such a referendum would include that of obtaining support for the creation of a Scottish state and the independence of Scotland from the United Kingdom. So,
I understand the arguments that have been put forward by you on both sides of the equation, leaving a state of indecision, and so that you can't advise one way or the other. Well, you can't positively advise that a Section 31 statement can be made.
yes.
But looking at individual matters which are raised, for instance, political significance, do you submit that it hasn't got political significance, or do you say it's an irrelevant factor? Or,
I say, be realistic about it. It does have political significance, just as the vote in relation to the withdrawal from the EU for UK had great political significance. But ultimately, when it comes to determining the purpose of the provision and its legal effect, the political fallout of that is irrelevant for this court. And that's really in line with what this court has said in Continuity Bill at paragraph 11 and indeed at paragraph 33, where the wisdom of the provision is not for this court. The politics of the issue is not for this court. And it's just as Lord Hope said in when he mentioned the fact that the question of political motivation is a different issue. So the politics of this, yes, we can see that it would have a political effect, but ultimately for this court is deciding a question of law, in respect of which they do not take account of the political effect of any vote that would arise from Scotland in relation to an advisory referendum. That has to be the approach, and it's certainly the approach that this court has spoken about frequently in the way in which they deal with these often sensitive constitutional matters.
and accordingly, paragraph 124 of Miller that has to be read.
Yes, that's right. And I think what was important in the Miller case was what Lord Neuberger said about what would then follow on from the advisory referendum, which is that there would have to be a vote in Parliament. And the members of Parliament were duty-bound constitutionally to vote on that. I can't quite remember his words as to how they should vote, but they certainly had a constitutional responsibility to vote in relation to that matter as to whether or not they approved or otherwise of the decision of the referendum. Yes, and Miller...
I do apologise, but you also referred to the background materials. Are those background materials admissible?
So I think when one looks at the I think paragraph 25 of Martin against Most,
yes,
and the discussion in Imperial Tobacco in the Inner House, yeah, and in the House of Lords, they are relevant to inform the whole circumstances. They would be relevant to your consideration as to the effect in all the circumstances, certainly they would. That's why I refer to them here. They are relevant materials. Yeah. But I think Miller wasn't looking at the purpose of the referendum under the Scotland Act. It was looking at something else when it was being discussed in that case. But there's no question about the background being relevant, but ultimately the decision of this court is a decision that has to be one on a purely legal basis, and it is a legal question for this court. So I now turn to the argument that the Scottish Parliament does have competence to legislate for the referendum. As I've explained, in the anticipation of the focus of the Advocate General's submission, I'll spend more time looking at this argument, and I submit 6 strands to it. Firstly, the statutory test set out in section 29(3) is expressly directed to ascertaining whether the purpose of a provision, having regard in particular to its effect, relates to a reserved matter. The focus is not on the subject matter of the question asked of the population. It's therefore not sufficient to establish the requisite nexus between a legislative measure and a reserved matter, that the legislation concerns the reserved subject matter, or, in the context of a referendum, that it asks people about that subject matter. Secondly, this court has held that there must be a direct connection and sufficiently close connection between the purpose of a provision and a reserved matter. And I refer to paragraph 27 of the Welsh asbestos case, which I've looked at previously. It's at page 735 of the electronic folder. Further, the reasoning of this court in Legal Continuity Bill, to the effect that the bill of the Scottish Parliament would only relate to the reserved matter of international relations if by its terms it sought to disrupt or interfere with the conduct of international relations by the UK government, also suggests that the connection between an advisory referendum and a reserved matter would be insufficiently close and direct. As we've already seen, the court stated that there is relatively little scope for Scottish legislation to relate to international relations, unless such legislation were to purport to deal with the powers of the Ministers of the Crown to exercise its prerogative in foreign affairs, or to create a state of law in Scotland which affected the effectual exercise of that power. That was what we saw in the authority when we looked at paragraph 32, and again I'd refer to pages 837 and 838. In Continuity Bill, the court's reasoning emphasised the need for there to be some form of legal or direct practical effect of the law on the reserved matter for it to relate to that matter. Thirdly, if the exercise of identifying the purpose of a provision for the purposes of excluding legislation from the Scottish Parliament's competence by reference to section 29(3) is analogous to that adopted in the familiar process of statutory construction, that suggests a narrower rather than a wider purpose, being the legally relevant purpose. And in that respect, I refer to the case of Quinta Valley against the Secretary of State for Health.
I'm so
Sorry, I didn't catch that.
Yes. R. Quinta Valley against the Secretary of State for Health, which is Authority 49, and it's page EF 2931 and EF 2941. I'm referring from there to paragraph 8 of that judgment, EF 2941, where it says the court's task within permissible bounds of interpretation is to give effect to Parliament's purpose. And I quote there from Lord Bingham. So,
might it not be said that the concept of purpose in section 29(3) of the Scotland Act is a little bit broader than the rather more precise idea of parliamentary purpose or intention, which one uses when actually interpreting an act? Doesn't it allow one or require one to have regard to a broader concept of purpose than one would use strictly for identifying the meaning of the statute itself? I've just got at the back of my mind, for instance, when one's applying convention rights in the context of parliamentary legislation, you ask questions which arise under the convention rights, such as what is the aim or purpose of the legislation, and for that, usually you can have regard not just to the words of the statute, but to the sort of wider context in which the statute has been passed. Isn't it a similar exercise under Section 29(3)?
Well, I think that what's important is to say we're identifying the purpose of a statutory provision, and it's reasonable enough to look at the canons of the legal the cases that have looked at the process of statutory construction in looking at this Act. So it is important, I think, by way of analogy and by way of informing the process that this court has to go through in order to understand what's the purpose provision in Section 29(3) is to look at how this court has, in previous cases, considered two particular canons of statutory construction as being relevant. And I do say that it is important to have regard to Quinta Valley, for example. I know that Lord Reid made reference to the case Quinta Valley in the Inner House when he was looking at the way in which to approach the statutory construction in terms of the Scotland Act. And there are two particular statutory constructions that are relevant and should be noticed. So the first is this, that the purpose of a law is in the first instance to be derived from an examination of the words used, including any clause that expressly refers to its purpose. And in that regard, I would cite Bloomsbury International Limited against the Department for Environment, Food and Rural Affairs at paragraphs 10 through to 11. That's at the electronic folder beginning at page 3109 and the particular quote at 3120 I rely on is at paragraphs 10 to 11 and that was Lord Mance with whom Lord Walker, Baroness Hales and Lord Collins agreed. So that case looked at the question of how you look at the statutory provision that related to the landing of fish in the UK, and whether or not you looked at the question of, you interpreted the word landing by considering whether or not you only looked at those fish landed directly on UK soil or through imports or other sources. So the purpose of the legislation was of particular import in the Bloomsbury case. In addition to that, the second point that I would make from the two particular canons of statutory construction that I rely on comes from the case R against the Secretary of State for the Environment, Transport the Regions, ex parte Spath Home Limited, which is 2001 appeal cases, authorities at 46. The electronic pages are 285, and the quotes that I'm going to rely on are at page 2857 to 2862. In that particular case, the meaning attributed to words of an instrument is an objective question and not to be equated with the subjective intention of the minister or other persons who promoted the legislation, nor equated with individual members or even a majority of members of the legislature. As noted by reference to Legal Continuity Bill, in the context of reserved matters, the purpose of a provision may extend beyond its legal effect, but it's not necessarily the same thing as political motivation. So I think that whilst there is obviously some care to be taken on applying those canons of construction, I do say that they point to the legally relevant purpose of the proposed bill being the holding of a referendum to ascertain the views of the people of Scotland on the issue of independence and not the motivations and wider aspirations of the individual parliamentarians or members of the Scottish Government. And I would remind the Court that Section 1 of the Bill, the purpose provision in the Bill, is that it's to make provision for ascertaining the views of the people of Scotland. That is the purpose of the Bill, and it's clearly stated. The purpose doesn't extend to securing independence. The purpose of the Bill is to ascertain the views of the people of Scotland. Ascertaining those views is, in this Bill, the legally relevant purpose, and it would not relate to the reservation of the Union in paragraph 1b of Schedule 5. The question that would be posed to the Scottish people is neutral between a yes and a no vote. The terms of the proposed question are therefore neutral as to whether Scotland should be independent. The form of the question to be used is to be approved by the Electoral Commission, and it is the same form of question that was used in the 2014 referendum. Section 2.5 of the Referendum Scotland Act, which we've looked at, which is at EF 2175, would require the Electoral Commission to consider the wording of the question and publish a statement as to its intelligibility as soon as practicable after the introduction of the bill. And more generally, the proposed bill is not directed at any particular outcome. Indeed, the general provisions on the conduct of the referendum, which are adopted in the bill by Section 4, are directed towards ensuring a fair and balanced campaign. Such a bill could be supported by parliamentarians and others who want the Scottish voters to reject independence. So the question to be posed is neutral. And therefore the motivations and wider ambitions of the Scottish Government represent a subjective intention which is not to be equated with the objective purpose of the bill. The objective purpose is clearly stated in Section 1, that is to ascertain the views of the people of Scotland. That is the objective purpose of any provision which sanctions the holding of a referendum. The purpose is not changed by the motivations of those seeking to hold the referendum. Fourthly, I say that Section 29.3 requires particular attention to be given to the effect of a provision. The limited legal and practical effect of a bill to hold an advisory referendum can be said to support the view that the purpose of such an instrument is to ascertain the views of the people of Scotland that relates to the Union in only an indirect or consequential way. So the legal effects of the bill would be limited to the facilitating the holding of a referendum vote, identifying those eligible to vote, the timing of the vote, and the affirming that the Referendum Scotland Act 2020 would apply. The bill would not purport to alter or impede any legal rule constituting or affecting the union of the kingdoms of Scotland and England, either directly or indirectly. The referendum would have no prescribed legal consequences arising from its result. It is not, unlike some other referendums, self-executing. For example, the 2011 referendum on the parliamentary voting system. The Advocate General refers to the legal effects in terms of organising and holding of a referendum. I say that these can be argued as not being legally relevant effects. They would only be relevant legal effects if the reserved matter was the holding of a referendum. But as we've seen, holding referendums is not reserved. To the extent that the Advocate General points to the authority conferred upon returning officers and the like, in no way can those be said to be anything other than loosely and consequently connected to the reservation in paragraph 1b of Schedule 5. Beyond the immediate effect of ascertaining the will of the people of Scotland, the practical effects of an advisory referendum are properly characterised as speculative, and there is authority that speculative consequences do not establish the requisite nexus required by section 29(2)(c). My Lord Reid in Imperial Tobacco emphasised that the courts are not equipped to speculate on what consequences will follow the enactment of laws beyond those that they prescribe. He stated at paragraph 133, electronic folder 592, that the court is not equipped to predict the ultimate long-term effects of the provision. Furthermore, it can be argued that it would also not be constitutionally appropriate for this court to take account of the possibility of future legislation of the UK Parliament. In Yalland and others, at paragraph 19, Lord Justice Lloyd Jones and Justice Lewis in the Divisional Court emphasised that the court should not seek to second-guess whether legislation will be passed by the UK Parliament. At paragraph 19, he said whether any legislation is to be introduced and the form that any legislation should take is a matter for Parliament itself and not a matter for the courts. And to similar effect, Sir John Donaldson, Master of the Rolls, in R against Her Majesty's Advocate, Treasury ex partes medley, 1985, Queen's Bench, at page 666 C to D, which is at page 2667 of the folder, said it behoves the courts to be ever sensitive to the paramount need to refrain from trespassing on the province of Parliament. Likewise, this court cannot second-guess the UK's Parliament's responses if a referendum returned a result in favour of independence. As Lord Neuberger stressed in Muhan, parliamentarians are not bound to vote in accordance with the outcome of a referendum. So therefore, in referring to the effect of a provision in section 29(3), the UK Parliament should be presumed to have meant the direct effects prescribed by the terms of the legislation, and in any event, not effects that are contingent or dependent on future legislation to be enacted by the UK Parliament. And further, the following other points can be made about the wider effects of the proposed bill. Firstly, the consequences attendant on the outcome of the referendum would be political. The Government of the United Kingdom has given no assurance or undertaking as to how it would act if the referendum returned was a yes vote. Even if a majority of voters were in favour of independence, then the practical realisation of independence would be dependent on political decisions and actions of a number of independent parties and bodies, in particular the Scottish Government, the Scottish Parliament, the UK Government and the UK Parliament. As I've just mentioned in Muhan, Lord Neuberger explained at paragraph 47 that if the issue came before the UK Parliament following a Scottish vote for independence, members of the UK Parliament would be free, indeed constitutionally bound, to vote as they saw fit. And the fifth strand to the argument is that the objection that the aim of Schedule 5 is to reserve to the UK Parliament matters of concern to the entire UK, and comments made by the UK Government in the 1997 White Paper concerning the integrity of the United Kingdom can be answered really in much the same way. The holding of a purely advisory referendum does not take the question of the Union out of the hands of the UK Parliament, nor does it purport to do so. the 1997 White Paper did not address the question of referendums, and it cannot be taken as suggesting that the Scottish Government is precluded from ascertaining the views of the population of Scotland on any subject matter reserved to the UK Parliament. Sixthly, other features of the Scotland Act do support argument in favour of an advisory referendum being within competence. Firstly, it is a necessary implication of the devolution established by the Scotland Act that the Scottish Government may negotiate with the UK Government about reserved matters. It is integral to Section 30 of the Scotland Act, by which modifications can be made to, for example, Schedule 5 by order in Council, approved by both houses of the UK Parliament and the Scottish Parliament, that the Scottish Government may have regard to and discuss adjustments to Schedule 5. Given that Section 30 has been used to modify, for example, reservations relating to Export Credits Guarantee Department, there was an order in 1999 and a relevant statutory instrument. In addition to that, interception of communications and surveillance, and indeed insolvency law, it's implicit that such modifications were approved by the Scottish Parliament, and it's self-evident that the Scottish Government must be empowered to discuss proposed modifications. That is reinforced by Section 63 of the Scotland Act. I have a copy of that section, but that particularly allows for the conferral by order in Council of functions on Scottish ministers beyond the general transfer of competence. So Section 33 is not in the bundle, but I can pass it up after court for my lords and my lady.
I'm so sorry, did you say Section 33?
63. So that allows for the conferral of functions beyond the general transfer of competence. And such an order, if it's to be made under Section 63, requires approval by the Scottish Parliament before it can be made. And the procedures involved in the transfer or conferral of functions is contained in Schedule 7, paragraph 1 of the Act. And I also have a copy of that. So accordingly, it has to be that it's inherent in the entire scheme of devolution that both the Parliament and the Government can consider, discuss, debate and ultimately vote upon proposed changes to the boundaries of legislative and executive competence. In order to exercise such functions in an informed and democratic way, the Government must be able to canvass the views of the people of Scotland on such issues. Reflecting these features of the devolution settlement, political parties can and do campaign in Scottish general elections on policies relating to reserved matters, testing the views of the electorate in general elections on such matters, and taking office on the basis of policies relating to such matters. Most obviously, of course, Scottish independence, but it might relate to any of a large number of reserved matters. There are various examples of the Scottish Parliament debating and passing motions in respect of reserved matters, as was envisaged from the outset of devolution, and I refer to some detail of that in paragraph 45 of my case. So it is significant that the scheme of devolution created by the Scotland Act allows for forms of democratic participation beyond the exercise of the franchise in general elections or ad hoc constituency elections as a means for testing the views of the people of Scotland. By way, for example, Citizens' Assembly of Scotland convened in 2019 and 20, and the Citizens' Assembly on Climate Change in 20 and 21, which was convened under the Climate Change Scotland Act, added Section 9 of the Climate Change Emissions Reductions Targets Scotland Act 2019, added by Section 9, were both exercises in deliberative democracy. In addition, and as I've already explained, the Scottish Parliament can hold referendums to ascertain the views of the people of Scotland on particular issues, and it has a regulated process for holding referendums under the 2020 Act. So the devolution settlement reflects a mixture of principles of representative, deliberative and direct democracy, and also reflected in the fact that devolution settlements for Scotland and Wales now declare that the devolved institutions can only be abolished on the basis of a referendum of the people of those countries. In that respect, I refer to section 63A(3) of the Scotland Act and the Government of Wales Act, section A1, subsection 3. The Northern Ireland Act of 1999, in implementation of the international legal obligations under the Belfast Good Friday Agreement, includes a referendum requirement in respect of Northern Ireland's place in the UK, and that is section 1 of that Act. So given these features of the Scotland Act and the manner in which the devolution settlement operates, there are reasons for concluding that the Scottish Parliament is not constrained when ascertaining the will of the Scottish people, and that it can do so even where the question is concerned with the subject matter of a reserved matter. Notably, both of the citizens' assemblies referred to above produced recommendations concerning reserved matters. Such matters, merely by dint of being reserved, are not as such no-go areas for the Scottish Parliament or the Scottish ministers, and they're entitled to ascertain the views of the population on them. If they could not do so, the Scottish ministers would be precluded from consulting the people of Scotland on a wide variety of issues, whether by referendum or other form of consultation exercise. By way of example, casinos or daylight saving time provisions. These are in B9 and L5 of Schedule 5. These are reservations. So they couldn't, for example, consult the Scottish people on whether or not the way in which our clocks operate in Scotland, which can sometimes be challenging for young people going to school in the morning during the winter times, they couldn't consult on whether or not there is a reason to consider that there should be at least some discussion with the UK Parliament about changing daylight saving time. So I say that the Scottish ministers, it can be argued, are not precluded from consulting the people of Scotland on a wide variety of issues, and they are not precluded to consult the people of Scotland on the issue of independence. So to summarise my points, the words and provisions of the bill indicate that the legally relevant purpose is to ascertain the wishes of the people of Scotland on their own future. The wider motivations and aspirations of the Scottish Government and other political parties are not legally relevant. The legal consequences of the bill are relevantly nil. Any practical effects beyond ascertaining the views of the people of Scotland are speculative, consequential and indirect, and should not be properly taken into account. It can therefore be argued that the purpose of an advisory referendum, such as prescribed in the Scottish Independence Referendum Bill, has at best an indirect or consequential connection. I refer to the Welsh asbestos case at paragraph 27, and so it has at least an at best indirect or consequential effect to the Union, and it doesn't have a direct or short-term effect. And I refer there to Imperial Tobacco against the Lord Advocate in the Inner House at paragraph 133. It doesn't have the connection or involve some practical impediment or other effect necessary for it to be outside competence. So even if the criteria included purposes that had a loose or consequential connection to the Union, ascertaining the wishes of the Scottish people with its purely indirect, contingent, and speculative consequences for the Union would be insufficient to satisfy the test. So can I then conclude on the issue of the reservation of the Union? Whether the referred provisions relate to the reservation of the Union depends to a significant extent on how broad a meaning is given to the effect of any referendum within terms of section 29(3). If its effect, for the purpose of determining whether it relates to the reservation of the Union, embraces the political consequences of any yes vote, then it may be beyond the competence of the Scottish Parliament. If, however, its effect is determined by its legal consequences and immediate effect, obtaining the views of the Scottish people on the subject matter of a reserved matter, then it may not relate to the reservation and thus would be within the competence of the Scottish Parliament. So then, moving on to the arguments as to whether or not the referred provisions relate to the Parliament of the United Kingdom, in that respect referred to Schedule 5, paragraph 1c. Paragraph 1c of Schedule 5 identifies that the Parliament of the United Kingdom is a reserved matter. In Legal Continuity Bill, it was held that the reservation encompasses the sovereignty of Parliament, and I refer there to paragraph 61. So the argument that the referred provisions relate to the reserved matter of the Parliament is as follows. If Scotland became independent, this would involve a reduction in the scope of the UK Parliament's powers, and I refer to Muan at page 672 at paragraphs 17, 71, 91 and 102. Indeed, if Scotland became an independent country, members would no longer be returned to the UK Parliament from Scotland, and it would become the Parliament of England, Wales and Northern Ireland. The purpose of holding a referendum on independence, even though it is advisory in nature, would be a purpose that relates to such a diminution in the power of the UK Parliament for essentially the same reasons that I have given in relation to the issue of competence. In relation to the case that the reserved provisions do not relate to the Parliament of the UK, the argument that the referred provisions do not relate to the reserved matter of the Parliament is as follows. The Legal Continuity Bill case made clear that the reservation of the Parliament of the UK is not infringed in circumstances where the authority of the Parliament to change the law is not affected. It therefore dismissed a submission that Section 17 of the UK withdrawal from the EU Legal Continuity Scotland Bill, which would have made specified delegated EU legislation dependent on the consent of the Scottish ministers before it could take effect in Scotland, related to the Parliament of the United Kingdom. This court at paragraph 63 held, nor are we persuaded that Section 17 impinges upon the sovereignty of Parliament. Section 17 does not purport to alter the fundamental constitutional principle that the Crown and Parliament is the ultimate source of legal authority, nor would it have that effect. Parliament would remain sovereign even if Section 17 became law. The court preferred to analyse any practical impacts on the ability of the UK Parliament to realise its policy goals by reference to Section 28(7 by means of Schedule 4. At paragraph 64, the court makes reference there, but the provision of Section 28(7 doesn't arise on this reference. But since the proposed bill would establish only an advisory referendum, it would not purport to restrict the powers, authority or jurisdiction of the UK Parliament. It would not be analogous to the UK withdrawal from EU Legal Continuity Scotland Bill in having direct legal and practical effects on the UK legislation. Changes to certain of the Articles of Union can only be effected by the UK Parliament. That's paragraph 1(2) of Schedule 4 to the Scotland Act. And the UK Parliament's constitutional role is entirely unrestricted by an advisory referendum. In the words of this court in Legal Continuity Bill, the proposed bill does not purport to alter this fundamental principle, nor would it have that effect. So I would wish to make some concluding observations then, having taken the court through these arguments. Since 2007, at 4 successive Scottish parliamentary elections, the Scottish electorate has returned governments committed to Scottish independence. Separately, at each UK general election since 2015, a majority of MPs from Scottish constituencies have been elected on the same manifesto commitment. Against that background and long-standing consensus that Scotland has the right to self-determination, to what extent, if at all, the holding of a referendum relates to a reserved matter is a question of fundamental, constitutional and public importance. Despite the highly charged political debate, it is a question of law. It is therefore a question that can only be authoritatively determined by this court. I believe it's in the public interest that clarity be brought to the scope of the Scottish Parliament's power in respect to this issue. Accordingly, the Lord Advocate in Scotland has invoked for the first time the right under Scotland Act to refer to this court a devolution issue which is not currently the subject of litigation, and it's done so for the benefit of the Scottish Parliament, the Scottish Government and the people of Scotland, and indeed people throughout the United Kingdom. The outcome of this reference is of particular importance to the Scottish ministers who have sought to, who would wish to introduce a bill on the referendum question if an answer to the reference is given in the negative, and that would be very much their wish. But it is, in this case, a matter that I bring before the court as a result of my retained function as a Lord Advocate, and I seek the court's ruling in order to inform this critically important question. There are 2 issues that I think that arise from earlier on today that would require some answer, and it may be that we need a little bit more time to do some further investigation. I was asked for whether or not there was some information available to indicate why it was that the paragraph 1F of the schedule to the Act relates only to questions about reserved matters. This was looked at before the case, and in researches we came across internal communications between the UK Parliamentary Council and the Scottish Office, and we do have communications between these 2 offices in relation to this matter. But there really is no assistance from the parliamentary debate or the internal materials. And I submit that it's reasonable to suggest that paragraph 1F reflects recognition by the Parliament that it's not possible to foresee all circumstances in a question about a reserved matter could arise, and an intention to capture all such circumstances without exception. One possible explanation for 1F not extending beyond reserved matters is that at the time of the legislation, reserved matters was a new concept at the heart of the devolution regime, in which no existing jurisprudence was available, and therefore in respect to which it may have been thought that there was a need for a particular provision under Schedule 6 to ensure that these questions could be brought for the consideration of this court.
I would have to look it up again, but didn't the original devolution to the Northern Irish Parliament in 1922, didn't it operate on the same model of reserved matters?
Yeah. So that's something that we've yet to look at, the Irish background, and it's something that we will do so. Yeah. Okay. We couldn't find any of the explanatory notes for what act was it? the Northern Ireland Act 1998, but we haven't looked any earlier than that. But we will undertake that exercise and try and do the necessary comparative exercise that might inform.
I was just concerned that the concept of reserved matters was slightly older than 1998, but I stand to be corrected. And,
very well. Well, I suppose it was new for Scotland. That's possibly what I mean. So is that possible explanation? Is all I'm saying. But there's really no assistance from the parliamentary debate or internal materials. We'll continue to look, but there was quite an exhaustive search done before today on that. Lady Rose asked a question on whether or not a member's bill could be challenged under paragraph 34 of Schedule 6. That's where a member chose to introduce the legislation and confirmed that in their view, it was within competence. I would answer this question by saying it really wouldn't arise in practice, as in practice, the Lord Advocate doesn't refer a bill until after stage 3 in that respect. But I wouldn't rule out that it could be challenged under paragraph 34 in the right exceptional circumstances. So it could be done, but in practice it really doesn't arise. And there's a particular involvement of the Lord Advocate at stage 3 in the private member's bill procedure for referral to the Supreme Court on a question of legislative competence.
Perhaps it would be helpful if you were to explain to us what the Lord Advocate's role is at stage 3.
Yes, so I can give that in writing. I do have.
If that's more convenient.
I think that's possibly more helpful because it's quite. I do have some material here that could easily be prepared and handed up, along with, if we can get it, some further background material on the issue of schedule. The schedule to the Act and paragraph 1F.
And just to help me, stage 3, what does that
mean? So that's in relation to the point at which the bill has been introduced. It's gone through the relevant processes within Parliament in terms of debate, committee stage and amendments. And the final stage in the process is stage 3. And that's the stage at which the Lord Advocate would then consider whether or not, as a result of the terms of the bill, or indeed any amendments, that the case should be referred to the Supreme Court in terms of a legislative competence issue. But I can easily give my Lord a flowchart on that.
Yes, no, I think I've understood from your explanation. Thank you.
Is that something different from the Section 33 process?
So the Section 33, I just need to check Section 33. It would be within that, yeah. I think it's part of Section 33 process, but it's just called Stage 3, I suppose. It's part of the process within Section 33 that there is the scrutiny of the bills.
As I understand it, Stage 3 is essentially the temporal period defined in Section 33 and subsection 2.
Yes.
Right. Yes, thank you.
So unless there's anything else, those are my submissions.
No, we're most grateful, Lord Advocate. You follow the statement. Sir James.
My lords, my lady, I'm going to take the issues of jurisdiction and discretion together and try and focus the submissions a bit under that composite heading. The starting point we submit for the issue of jurisdiction in particular is that there is clear and consistent authority, including at this elevated level, that it is not appropriate for courts generally to engage with abstract questions of law until the facts are known. And the case law has made it entirely clear that the facts for this purpose include whether possible legislation will in fact be passed, what its precise terms will be, and indeed very often a factual matrix to which such legislation actually applies. That case law doesn't just identify those as the relevant facts for the purpose of the principle. It examines in some detail why the courts take that position. And I wanted to take you to 2 or 3 authorities, if I may, on those matters. The first of them is the Attorney General for Northern Ireland's reference in this court behind tab 12, starting at page 866. And the relevant page, sorry, it's maybe very inconvenient to give you the start page if you're doing it electronically. 872 is the page I actually want. And you'll see the sentence at the beginning of paragraph 28 at the bottom of 872. In general, it is desirable that legal questions be determined against the background of a clear factual matrix rather than as theoretical or academic issues of law. And then you'll see in the remainder of the paragraph, which I don't read out, the basic reasons for that. It was a theme to which Lord Kerr returned in the second of the Attorney General references. I don't take you to that second Attorney General reference now, because we've summarised the relevant bit in our case at paragraph 37. So that's the first set of cases, as it were. The second of them is a decision of Lord Justice Lloyd Jones, as he then was, and Mr. Justice Lewis in Yallen, to which reference has already been made. That is behind tab 56, and the relevant paragraph for our purpose is on page 3317 in the electronics. 3317. And as you see, para 25 says it will rarely be appropriate to consider such issues when they may depend in part on factual matters or future events, since until those factual matters are established or the events occur, the courts will not be in a position to know with sufficient certainty what issues do arise in a particular case. Similarly, when matters may depend upon or be affected by future legislation, it will generally not be appropriate to make rulings on questions of law until the precise terms of any legislation are known. And that paragraph, with those principles and that explanation there set out, was effectively dispositive on the facts of that case.
Well, in the circumstances of this case, there's a majority in the Scottish Parliament, and we're told that the legislation is going to be proposed, and surely we can take it it's going to be passed.
My Lord, I don't think you can,
Why not?
with respect, take that as read.
Why not?
People might have different views. MPs haven't yet voted. The mere fact that there's a government majority may lead to that result, and it may not. And my Lord shrugs your shoulders, so that's unrealistic. Well, it's a matter for you to take into account. But normally the views of courts are that even if a government has a majority, and even if a government is proposing legislation, it doesn't necessarily follow that it will be passed at all, and if it is, will necessarily be passed in precisely the terms in which it sits when it's introduced.
This is, in essence, a very short piece of legislation. One can hardly imagine fundamental changes to the question or to the operative parts of it.
Well, my Lord, you may very well be right. I simply don't know. There may be operative parts that get changed by way of amendment, there may not. In any event, I'm simply on the principles at the moment rather than necessarily how it applies here. I don't want to diminish the force of the point my Lord puts to me. I'm not entirely unrealistic. It is a short piece of legislation, and I suspect that on both sides' cases, the issues that would arise at the later stage in relation to competence will arise come what may, and irrespective of the precise form of question. So I'm not seeking to deny that. This is in large part, as it were, a setup to the submissions I'm going to make, which are of broader significance in this case, about how jurisdiction works under the Scotland Act, where you will need to bear in mind not just the facts of this case and the potential clarity of the legislation, but more generally how the Act works, and in particular the interrelationship between Section 31(1) and Section 1, Paragraph 1F of Schedule 6. That's the key bit for present purposes, and that's a bit that isn't confined necessarily, or at all, to this particular piece of legislation. So that's the broader answer of principle. The third of the authorities I wanted to show you to involve one of the members of the court in Yallen, but not the other. By this point, Mr. Justice Lewis had become Lord Justice Lewis and was sitting with Mrs. Justice Steyn in Counsel General for Wales, tab 59, page 3530. And the relevant paragraph for present purposes is paragraph 33, starting halfway down, or a little over halfway down, page 3530. Can I invite the court to read yourselves that paragraph? Quite a long paragraph, but maybe more convenient to read it yourselves. So you see the themes. Governments, law officers and everyone else, and legislatures must inevitably form their own view about whether proposed legislation is compatible with various superarching pieces of legislation, e.g. the HRA. There's nothing new or surprising or unfortunate that the courts get involved only after legislation is enacted and not before. And the reason for that is because courts do not, in general terms, for all the reasons I've gone through, give advisory declarations in the abstract. The court specifically noted in that paragraph, as you've seen, that the equivalent law officers and the presiding officer in Wales were likely to have to form a view about competence and reference, but they do not seek advisory declarations prior to the passing of bills. So that's the critical paragraph for present purposes from Counsel General Wales, and you will note that the Court of Appeal dismissed the appeal. I don't need to go to that dismissal for present purposes. If you wanted, it's at page 3562 in the authorities bundle. And since the service of our written case on this reference, i.e. this reference, this court has refused the Counsel General permission to appeal further to this court.
But, I mean, in our case, might it not be said that it's not going to be an advisory declaration and it's not in the abstract? I mean, if the court rules on the matter, it will be deciding the point in the context of this bill, won't it?
My Lord, it will, but it will be deciding the point in the context of a draft bill that hasn't been introduced into the Scottish Parliament and has yet to go through those processes. And I'm going to take you through the processes that the Scotland Act envisages before a reference in relation to a bill can be made. So, my Lord, I don't seek to suggest that this paragraph is directly on all fours, and I fully take the point you put to me. But this is the basic rule, and the purpose of taking you to these authorities is not to say we are in pari materia. It is to say this is the basic starting point, well known, well established, against the backdrop of which Parliament then legislated in the Scotland Act to set up what we will submit is a limited set of circumstances in relation to draft bills where Parliament, where the courts can do precisely the thing they wouldn't otherwise do, namely to give a view about the competence to pass particular as yet unenacted legislation. They take it to the final stage of passing and then the courts get involved. So the Scotland Act 1998 and the equivalent other pieces of devolution legislation represent an exception, and we submit a narrow and carefully circumscribed exception to what otherwise would be the basic principle as adumbrated in these cases. That's how we put that point.
It's an exceptional jurisdiction in a number of ways. In also the fact that that this court is exercising an original jurisdiction.
Yes.
In proceedings which can only be initiated by law officers.
Yes.
It's very much giving this court a constitutional jurisdiction. So it's somewhat different from, for example, the judicial review proceedings in the Counsel General case.
My Lord, it is. And as I say, I don't seek to rely upon these cases being in pari materia. They're obviously different. You've got to deal with a specific, constitutionally centred, original jurisdiction that is set out in the Scotland Act. The question is, how far does that go?
Yeah.
That's the ultimate question of interpretation, which is the issue you're going to have to grapple with. Keating's, I was going to refer to as the final in the quartet of cases establishing the general principle, might be thought to be a little bit closer to our sort of situation, particularly in relation to the facts. And Keating's is behind tab 14, and the relevant passages for present purposes start on 899. And again, I don't invite you to go through them all now, but you will see from the reasoning of the court, this is Lord Carloway, the reasoning of the court at paragraphs 51, and particularly 51 through to the end of 55, reject the attempt to inveigle the court into ruling on the draft piece of legislation for a referendum of the kind that we're concerned with, and they did so on the basis of those traditional principles. There were lots of imponderables in that case, including whether or not a bill would in fact be introduced and how it was going to turn out. And many of those imponderables do at least have some resonance here. The bill hadn't been introduced. As the court put it, a draft bill has no legal status. If introduced, a bill may or may not be passed by the Scottish Parliament, said the court. The form of the bill introduced may be different. No matter what its initial form, said the court, it may be amended. Now, again, it could have been said to those representing the Advocate General in that case, well, isn't it obvious? They've got a majority. It's a pretty straightforward piece of legislation, but they were imponderable enough, at least for that purpose, to lead the court to the conclusion that you see set out at paragraph 55.
I thought at that stage the result of the election wasn't known.
My Lord, it wasn't. So there were more imponderables here, as I entirely accept.
Yeah.
But the ones I identified just now were taken as imponderables, as it were, from the reasoning of the court, as you see in paragraph 55. So we do submit that that basic principle is the key starting point, at the least, in considering the meaning and effect of the Scotland Act, and is important in considering discretion if you get to that stage. I wanted then to turn directly to the Act, recognising that this is a question of interpretation of the Scotland Act, with all its status of the kind my Lord the President has just reminded us of. And so far as the Act is concerned, I wanted to make two key initial points, if I may. And the first is that the legislation, that's the Scotland Act, sets out a carefully regulated and specific timetable and set of requirements before a reference can be made of a bill. So if you go into tab 1 of the authorities and get the Scotland Act, if I may, can I just remind you of the key provisions so far as this is concerned? The position essentially is that the bill must have been passed or approved in accordance with any standing orders that are made under section 36(1) and 5. I take that from section 33 sub 2 on page 141. So the power to make a reference is given to the law officers that my Lord the President identified. That's 33(1). May refer the question whether a bill or any provision of a bill would be within legislative competence. And we know what that means. That means the section 29(2) question. In other words, the various bases on which it will be outside that competence. And then sub 2, subject to subsection 3, he may make a reference in relation to a bill at any time during the period of 4 weeks beginning with the passing of the bill, and then any period of 4 weeks beginning with any approval of the bill in accordance with standing orders made by virtue of 36(5), which we'll look at in a second. So the basic position is that there can be no reference by the law officers under the scheme of this legislation until the bill has passed. And then there's a set period of 4 weeks within which the reference has to be made. So passing is the necessary and the mandatory temporal precondition to the making of a reference. What then of the stages of the bill is before you get to that point? Go forward, if you would, to page 146 and have a look at section 36. What this does is to make mandatory provision for the content of parliamentary standing orders of the Scottish Parliament. Standing orders shall include provision, as you see from 36(1), and then you see the various stages for general debate on a bill with an opportunity for members to vote on its general principles, for consideration of and an opportunity for members to vote on the details of the bill, and for a final stage at which a bill can be passed or rejected. So all of those things have to happen before the trigger in 33 for a reference can be made. And that's for a pretty obvious reason, which is to thrash out the content and actual detailed nature of the bill before any power to make a reference is made. You will then see, and we don't need to trouble too much with it, but you saw reference to 36(5) and the approval process earlier on in the provision I took you to, and you will see that 36(5) is effectively a reference back to 36(4). I'm not going to go through the intricacies of that, but it is at least worth chasing through those procedural intricacies as the alternative to passing as the trigger point for a reference. In a specific type of situation, you've got to have standing orders making provision for various other sorts of process that have to be gone through before the reference trigger point is reached. They are, in essence, and in very broad summary, matters where the subject matter of the bill are to do with how you get elected to the Scottish Parliament. So there is an intricate scheme for standing orders to regulate those parliamentary stages, and they include provision, as you see, for detailed consideration of bills by the Scottish Parliament. The prescribed legislative stages include specified opportunities for legislative reconsideration after the Supreme Court determines any reference. So there's provision made in this Act not merely for the process that leads you to the reference jump-off point,
But there are also provisions in the legislation that deal very specifically with going back to the Scottish Parliament after the Supreme Court has determined a reference. See, for that purpose, section 36, sub 4, standing order shall provide for an opportunity for the reconsideration of a bill after its passing if and only if the Supreme Court decides that the bill or any provision of it would not be within the legislative competence of the Parliament. So in other words, if you assume introduction, they pass, the statements are made, the bill is prima facie deemed to be competent, it comes to the Supreme Court. The Supreme Court disagrees, says no, that provision and that provision and that provision are not within competence. Standing orders have then got to provide for a process, or at least for the opportunity, for the Scottish Parliament to reconsider. So that's part of the built-in process. All of those processes presuppose that the draft bill has gone through the first essential stage of introduction. And I'll come back to that because section 31 and how it works is at the heart of the interpretive debate that you will have to grapple with. But all of those stages, as I say, are preceded by the requirements for the various statements and the offering of views. Then it gets introduced, then you have the standing orders, then you have come back if the Supreme Court decides any part of the past legislation is in fact outside competence. You will also have noted, and the President reminded us of it a minute ago, that as part of that intricate structure, only specified office holders can refer. See section 33, sub 1, at page 141, and they are the Advocate General, the Lord Advocate, or the Attorney General. You will also note, just to complete the intricacy of the process, section 32 sub 2, which is part of the provisions governing references and so on, and entirely obvious why this provision needed to be made. 32.2 is on page 137, and what it does is to preclude the presiding officer from submitting a passed bill for assent if a reference is made within that 4-week period. You can see why you would need that, because otherwise the bill was submitted for assent before the Supreme Court had offered the constitutional view on competence. So the key point to be derived from this suite of provisions, with all their care and intricacy, is that the United Kingdom Parliament in the Scotland Act has required that the stages of the legislative process in the Scottish Parliament be completed. The legislation specifically sets the end of that Scottish parliamentary consideration as the trigger for the 4-week window referred to in section 33.2. And the clear intention is therefore, at this stage, that the bill in the Scottish Parliament has gone through all of its legislative stages, all of those stages referred to in 36.1, so that it is in final form and simply awaiting assent. That's the only thing that needs to happen, is His Majesty needs to put the chop on it. It is the point at which the issue, therefore, bear in mind at least the basic themes from the case law I took you to earlier, it is the point, legislatively, it is the point at which the issue that will come before the Supreme Court is as close to not being abstract or inchoate as possible. You've done everything apart from His Majesty putting his chop on it. You will also note, as part of this legislative structure, and it is just a note, that there are relevant provisions within it, and provisions specifically made for orders in council to be made that would specifically modify both of Schedules 4 and or 5. You see that from section 30 sub 2 on page 131. And that was a point that was noted by the Lord President in Keating's at paragraph 55. You may have picked up that reference in paragraph 55 of Keating's to that power. And it was that section 30 power which was used to make the order in 2013 modifying Schedule 5, the bits that we're worrying about when we get to that competent stage, so as to permit the referendum which took place on the 18th of September 2014. The order, if you want it, is at tab 36, page 2164, but it followed, as you will recall, a political agreement that was reached between Her Majesty's Government and the Scottish Government in 2012, which you also have in the bundle. But section 30, for present purposes, sits as part of that scheme. You can change it if you want to, but it has to be done by that process, which is specifically provided for. So that's the first point I wanted to draw attention to in relation to the Act. It sets out a carefully regulated and specific timetable and set of requirements before a reference can be made. You can't just do it willy-nilly. It's very carefully done, and it's very carefully done with an eye to all of the line of case law I took you to earlier. It sets the time point for jumping off at the point where the legislation is in effect final apart from assent. Second point in relation to the legislation, it is also evident, and Parliament, that's the UK Parliament, will have appreciated this fact as well, that a variety of documents are likely to be created before introduction of a bill into the Scottish Parliament, and those documents will normally accompany the bill at introduction. So, explanatory notes, policy memoranda, committee reports, and so on. I say will normally, under the Scottish Parliament Standing Orders Rule 9.3, any bill must be accompanied by a financial memorandum and explanatory notes, and a Scottish Government bill has also got to be accompanied by a policy memorandum setting out the policy objectives. See page 6441 in your authorities bundle. And this point is of interest because those sorts of documents, which may be, perhaps, to come back to Lord Stevens, less necessary in the context of a simple bill with a basic purpose like this, but might be very, very important in relation to more complex legislation, which this scheme will have to govern as well, and whatever view you take on 31.1 and its relationship to Schedule 6, paragraph 1, will also have to work for. It's of interest because these sorts of documents have long been held in your case law to be particularly important as informing the consideration of whether or not the bill, or a bill and its provisions, are within competence. And that is no doubt because 29.3 puts the spotlight squarely on purpose and effect.
Can you just please give me the page reference again for Rule 9.3?
6441.
Thank you.
Is that one. And the importance of these sorts of documents, again, it's trite, so you probably don't need a reference, but if you wanted one, Martin and Most per Lord Hope at paragraph 25, page 397, but we've given you a host of other cases, no doubt unnecessarily, in our case at paragraph 13, which are references to the same end. The point is that those sorts of documents are likely in many cases to be integral to the consideration by this court of competence and therefore the fulfilment by this court of its constitutional role. And they will be lost.
And do those documents also include party political manifestos and statements by, on behalf of a political party?
My Lord, I'm not sure that those documents referred to in the Standing Order Rule will include those sorts of documents. But I don't think, if that's the purport of your question, that there's been anything in the case law, as it were, that limits for this purpose the source but from which you might derive assistance as to purpose. Does that make sense as an answer? So the reason that the legislation goes into this level of careful detail setting out the pre-enactment safeguards is obvious. The United Kingdom Parliament clearly recognised that lots can happen to a bill during legislative stages through the Scottish Parliament, including those that must be set up under the standing orders, given the requirements of section 36(5) that I've taken you to. Those processes affect the shape of what can then be referred. The legislatively inchoate must become coet. The United Kingdom Parliament also clearly recognised that if references are made in compliance with those safeguards, the issues that the Supreme Court will need to consider will then be capable of being considered with maximum certainty and with the maximum degree of assistance that can be provided to the important constitutional role, and indeed, to hark back to my Lord President's point, to the original jurisdiction that this court is then having to undertake under the Section 33 reference process. And all of this, we respectfully submit, was clearly and squarely recognised, i.e. all of this being the basic design and structure of the legislation, by Lord Carloway in Keating's, see in particular paragraph 60 at page 901. So perhaps to finish today, can I just make twin submissions at this point in the argument? The twin submissions are, first, that Parliament has been prepared to countenance a departure from the usual approach of abstinence, judicial abstinence, but has done so on terms. As a general rule, you don't give advisory opinions on hypothetical provisions in the abstract, still less on proposed legislation, because, well, not least because, that draws courts into policy making and legislative functions in a pretty uncomfortable way, and you need, therefore, the clear parliamentary authority that you have in the Scotland Act to enable that process to be undertaken. So the devolution legislation gives you, as it were, that legislative permission, but it does so in a very carefully delimited way that has obviously been designed with an eye to that case law, because all of the thrust of all of those provisions is to try to make as certain as can possibly be done that by the time it gets to you, the Act is in as final form as can possibly be mustered prior to it actually becoming law. And the second submission, which I leave you with for the purpose of today, is that with respect, the Lord Advocate's interpretation of the tail end and unspecific words that finish off Schedule 6, paragraph 1F, bypasses / undermines all of that. It is no answer to that point for the Lord Advocate to say, as she does, this is not a bill reference, so Section 33 is irrelevant. The Lord Advocate has carefully and deliberately chosen to frame her referred question around the terms of a draft bill. She's no doubt done so to try to reduce the force of the argument that it seeks a judicial ruling in the abstract, but the fact that it is not a bill reference under Section 33 is nothing to the point. Of course it isn't. But that is no answer to the objection that referring a draft bill at this stage, which has not reached the Section 33 stage, circumvents the exclusive statutory scheme that Parliament has gone to all that trouble to set up, with all the demerits that that process, or that jumping of the process, entails.
How do you get to the Section 33 stage if you cannot genuinely make a Section 31 statement?
My Lord, my answer to that, and I'm going to come back to it in more detail tomorrow as the next topic when I consider how Section 31 fits into this scheme, my ultimate answer to that question, given the time, is so be it. Parliament has set up a jurisdictional precondition to the introduction of a bill into the Scottish Parliament, which is that you need to be able to persuade, I was about to say even, but that would be disrespectful, even your own law officer. You can't even persuade your own law officer that you are within competence. The shutters come down under the scheme of this legislation. That's our ultimate answer to that question. But I'll return, if I may, in a little more detail to Section 31 tomorrow.
Well, in that case, we'll adjourn there for the day and resume at 10:30 tomorrow morning.